Why?
Direction was given for the paper book. Evocation records are has been arrived.
So it's incomplete. The record is incomplete.
Yes, my lord. The probate was required for proper activity. That needs to be worked.
So if there's already a direction, what has to be done now? The registry has to follow it up. No, give the details. We'll find out what has to be done. Give the detail of the case. Let's see. Can you show us you have a copy of the order? Let us.
There's the direction already. Direction was given.
Just find out what is wrong. Ask someone who is in charge. Further order is not required, sir. The office has to comply with this. If it is incomplete, they should issue a reminder. They should follow it up. We'll see. Just wait. We'll try to get it sorted out for you.
Number 1.
Call the next. My lord, one indulgence, my lord. My lord, actually, yesterday I've been appointed as a APP in charge of the circuit bench, my lord. So in that case, the person who was in charge, Mr. Adishankar Chakraborty, maybe some of the matters we may ask for adjournment because I'm just taking the briefs from him. So, my lord, in that case, please accommodate, my lord.
Number 2. Congratulations to you.
So, jail appeal.
Is any pending bail application?
My lord, it's a punishment, jail appeal. So, bail application is pending, and the punishment is life imprisonment.
Offenses?
Offenses, my lord.
302.
302. Rita, তোমরা আছো? 500 নিন।
Not true. Number 3.
Team number 3, Dr. Arjun Chaudhary is there. You go there. Take the bench. Table. দেখো শুরু করো আসলে এখানে আসতে বলা আছে অনিরুদ্ধ কোথায় রে অনিরুদ্ধকে একটু ফোন করে দেন ফোন করলে ফোন ধরে না সুভাষিস মিশ্রা অভিযুক্ত আছে
Yes.
Yes, my lord, in this case, so in this case, my lord, 14/3/2020, one incident was taken. It was a bigger one. So, one breaking company has been lost by one of it, who happens to be a deceased person. And as per the report company lost by one of it group, this case has been started of it on the section. So, Roshi, in this case, 45 notices have been ready. And Roshi, in this case, on 14/3/2022, this company was as such, it was a
Arjun.
Can you repeat that submission, please? Can you say it again?
yes.
Yes, what did you say? On 14/3, what happened?
14/3/2022, one incident was taken place at Bazaar place.
Yes.
Prison Bari. So subsequently, Navin Guru, in this case, PW1, last written complaint to effect that.
She is wife of the deceased.
He is the wife of this. No. This is a wife of Navin Guru. Okay. So as per the written complaint lodged by Navin Guru, this case has been started. Navin Guru lodged the complaint against some unknown person. So as per the written complaint lodged by Navin Guru, this case has been started by the Pulvazar page against this person under section 302. So Lordship, in this case, 45 cases has been already examined. So on 14/3/2020, where this Abid Guru was in his school, so he is a school teacher, school staff by laws. And on that day, there was an exam in his school. So at around 11:30 AM, he received one call. From his brother. He is way across to their period of 4 years. So, after receiving his call, he went to the PO in his house by his one colleague, Reddy Sharma. So, whenever he reached at PO, he found his house main door was locked. And he opened with duplicate. But then he found some Almira was broken, some articles were stolen away by some unknown person. But in this case, the person of the PW poll, it is good. We happens to be an eyewitness in this case. As such, he stated that he was that
PW4 is eyewitness.
yes, eyewitness. Then he reports that at about 9 to 9:38, I saw some unknown boy. At about 24 to 25, was coming out up inside the house of and this is house.
Paper book prepared,
Yes.
then the appeal should be hard on merit.
Yes. No.
But once paper book is prepared, my lord, there is no point of hearing the bail application.
No.
Because your lordship has to return the finding that the appeal is not ready to be heard, and that's why, my lord, the bail has been taken up.
Have to.
Yes.
So, he stated that he was that I saw some unknown person. He was coming out from the house of deceased at around 9:30, 9 to 9:30 AM. But he did not recognize the accused person, appellant. Thereafter, he was that after a while,
We are informed that paper book is not prepared.
Well, we found that.
What is, first tell us what is the manner of occurrence?
No,
As per the eyewitnesses
No, no,
account,
he's the main eyewitness.
EW4.
Yes, yes.
So what does he say? Where is his,
He's the main witness.
let us see.
He was there. First, he could not recognize this opponent. So after when he recognized it was his right opponent in this case. But there is a contradiction in this, my lord. Well,
Just give us 2 minutes.
There is no weakness to the incidents. So last thing together.
Yes.
My lord, in this case, there are lots of contradictions. And moreover, in this case, the affidavit for it is going to be reconciled via ID. It is not corroborated by any. Appears from issue doesn't order permission and sentences as record against the affidavit on subsequent of this law. As such, they have not been proved beyond reasonable doubt. Placing and categorical evidence that the case came under the circumstances has been alleged by them. My submission is that, my common submission is that the lordship would graciously please appear on.
He was on bail on earlier occasion. Custody trial.
বেরিয়ে আছে এটা একটু একটু হালকা করে খান না, এটা অসুবিধা হচ্ছে না পৌঁছালো। পাটটা একটু খালি ইয়ে করে দিতে হবে। আর একটু যাবে, আর একটু
Lord, in this case, I have one critical. Incident was taken based on 14 complaint. He lost the written complaint after 14 days. That is on 28 week.
Delay.
And
There is a delay in lodging the complaint. On 14/3/22.
yes, incident was taken place on 14/3/2020. Yes, that actual person, he lost the complaint on 28 week.
When the complaint was lodged.
Sorry.
When the complaint was lodged.
Complaint was lost, accident was taken place on 14/3/2020.
That is there.
As per his person, it is already recorded in cross examination. He lost the complaint on 28/3/2020.
What is the date of FIR?
Date of FIR is 14/3/2020.
So what do you mean he lost the complaint on 28?
Then he stated in cross examination that he lost the complaint on 28/3/2020. His complaint was.
Maybe the documents is FRS exhibited.
FIR is of
It appears on the date of complaint. How that
In
cannot
this
be?
case, the injuries are with by the sub-body weapon, but weapon offended weapon found in the blood object in the body.
It will be decided in that. Weapon found in
Blood object,
blunt object.
yes.
The injury sustained is by a blunt object.
So actually, as for person.
yes.
Witnesses, injury was sustained by sub-body.
Weapon seized.
Yes.
Weapon seized.
Yes, ma'am. But as for the, when the, offended weapon produced before court, it was blunt object.
Who said it is a blunt object?
Doctor. Doctor Soumya Kumar Parker, PW 44. Reports that it was examination in direct report that injury may be caused due to sub-cutting weapon. And we categorically report that in prosecution in PW 30 that MO exhibit is not sub-cutting weapon, it is not also.
Deposition sheets are not here. Deposition sheets are not here. So, judgment. How can we?
I think it is recorded in judgment.
No, that is recorded, but where is the depositions? Depositions are required to be used.
I have a certificate of retrieval.
How can we proceed? It is not with him. You have a copy. Is there any motive? Has any
No, the-
motive been recorded in the order? In the judgment?
The Honorable Supreme Court, my lord, has said in many cases that motive is immaterial. Even if there is no motive,
Judgment will come after you clarify the fact whether there is any motive or not. We asked you
Yes,
whether
but-
there is any motive.
but
We didn't ask you what the law is.
my
We
lord,
ask you a fact whether any motive has been established in the judgment or not.
Page 55.
That will come later, what the apex court has said and what is the law. So we are asking you whether any motive has been recorded.
Page 55.
the motive was, my lord, since he went there only for the purpose of stealing money, my lord, the entire thing. So motive was, my lord, stealing money.
So there is no, it is alleged that he has probably broken into the house for some theft.
No, he had a key. He had a key, my lord, here, and the eyewitness has said so that he has seen this person, my lord, going inside, and my lord, after some time, after we got the PW at a 4. After some time, my lord, he had come out, and my lord, later he came to know, the eyewitness came to know that his sister was murdered. So, my lord, this fact has not been, my lord, could not be impeached by the defense.
Not eyewitness's sister. It is eyewitness's sister-in-law.
His sister-in-law, sir. I stand correct.
Clear on that. He said that he went to the house. He called for her. She did not respond. When she did not respond to his calls, he rang her up on the phone.
My lord.
Again, she did not respond. Then before going away, he saw this man coming out wearing a blue mask and a grey cap. That is his statement.
Lordship.
And that is how he implicates this man. So we are asking you, how does he know a man wearing a blue mask is this person? Unless there is a motive, any pre-existing kind of animosity between the parties, which has directed his thought in this way, how it has been alleged and how he has been identified.
From the deposition, it is clear that he was able to identify.
That's what we are asking you. See, if you are not clear on facts, go through it.
Lord,
Law will
whether
come
your
to
lordship is
the-
having the copy, I do not know, Lord, depositions.
So
No, no.
therefore, we are asking you, be clear on facts. You take a copy. You said you have a copy.
I have
Go
a
through
copy.
it. Go through it. We'll consider it.
My lord.
We'll take it up on Monday. Let him read the deposition.
So one thing is there, my lord, in this case,
See, the allegation which we have found in the
Yes,
FIR is
in judgment copy,
Second, ma'am.
that this person PW4, he went from his school at about 10 or something in the
Yes.
morning. He went to the place of occurrence.
Occurrence.
He called for his sister-in-law from the downstairs. It's a 3-story building having an iron gate which is locked.
Lordship.
Now he called, she did not respond. So he called her on phone. Again, she did not respond. So he called PW1 saying that she's not responding. I'm going, I will come back tomorrow.
Yes.
Then PW1 was later informed, but he says, I saw one man wearing a blue mask and grey cap coming out or going in at 12 o'clock. And then this man learns in his school that there is a murder taken place in his house. Then he find that his wife has been murdered. There is a dog also there. He has also been done to death. The dog has also been done to death. They are lying in a pool of blood in the kitchen. So therefore, how this blue mask has been identified, that is one issue. Why this man suspected him? Is there any pre-existing animosity? The material in this regard, just go through
I'll
it.
come back, my lord.
Then we'll see
Yes.
whatever the law is. We'll
Lordship. My lord.
my lord, in this case, one thing, is that, my lord, in judgment copy, page number 46, it is mentioned there North University doctor. MO,
Is there any point in listening you today when he is not?
not to make it tomorrow because I all the way from Darjeeling. It's very difficult to from Jalpaiguri now is season in Darjeeling all the time traffic jam because I will start at in the morning 5:30. Make it tomorrow.
Not today. Please ask your learned friend to come back. Oh, how will you see the deposition? I need to. Number 4.
Roshib, I am the newly appointed advocate of this matter to legal aid service. Roshib, this is the appointment letter.
Medical. My lord, in digest lordships, item number 4, Subhashish Mishra is conducting lawyer for the state. And he had been to Bangalore for emergency treatment purpose, lordships. So today it's not possible, lordships. One day accommodation.
Roshib, my appointment has been given by the order of the division bench. I am entitled to proceed this matter. But I am appearing last night. I had one conversation with my client. Today, I had a conversation with my client. And she is asking mother.
Have you taken, yesterday we asked you to take steps. What did you do?
Roshib, I am newly appointed
Hey, pass number ka
of this case. And while advocate found to give me the brief of this matter.
Were you appearing yesterday when this matter was called?
No, yesterday is not today.
The day before yesterday.
Yes, Lordship, actually, on Monday, I am not able to come.
Then did you ask your friend what happened on Monday?
Lordship, I am.
Did you ask your friend who was there to find out what happened on Monday? Why?
I am just receiving the appointment letter today morning. No, I have not received
That case where the court directed that the legal aid should take up the matter. Somebody was appearing on Monday.
I have. Appearing on Monday.
There was another advocate also.
Yesterday night I had a conversation with my client. Today I had a conversation with my client. But they have no objection if I talk about.
Okay, ঠিক আছে, ready আছে।
Already, last occasion of the circuit bench, every day he is coming and demanding adjournment. Yes, the Lordship, kindly see the last order of the. He is appearing and also demanding the. I put the matter with me. How the legal.
Yes, what do you want?
Lordship, I am entitled to proceed this.
What do you want today?
I am demanding the brief and the paper proof of this.
Take the brief. Take a copy.
The client is to do the matter.
Let's first be directed to hand over the copy. The government, the paperwork is there.
Last circuit bench every day.
We are not going to go into that, please. There is an order, we'll go after the order. We are not going to recall any order.
Oh, wow.
How will you get the copies? How will you get the copies?
Department may be directed to hand over the copy of the paperwork to that person who is appointed by the legal services committee. Otherwise, that can be done. In pursuance of the direction, earlier direction passed by the coordinated bench of this court dated 25/3/2026. one learned advocate is appointed by the Calcutta High Court Legal Services Committee, Jalpaiguri. It is submitted by the learned advocate, who is appointed by the Calcutta High Court Legal Services Committee, that presently he has no documents to proceed with the case. Paragraph department is directed to hand over the copy of the paper book to the learned advocate, who is appointed by the Calcutta High Court Legal Services Committee, Jalpaiguri, before the date fixed. Let the matter appear in the list in the next week. Next. Thursday.
Call the number 5.
For the state, my lord.
You just.
Number 5. How do we get how do we get copies of the deposition?
I will send you the.
You have a copy. I have been provided a copy by him. I have a xerox. So give us 2 copies today, please.
Yes.
My client is. I have contact with the client, but
Yes, please are paying for the legal service.
I received the appointment letter, but so far, my understanding has already appeared. My lord, whatever my lord is doing, I have.
You are conducting the case of your client in such a manner. On earlier occasion, you are repeatedly absent. That's why the order was passed.
Sir, I was also in difficult. I could not attend. My junior was there. So my name was there.
This matter. Earlier matter. All that lawyer appears does not appear in the earlier matter. Already bail was granted.
Well, Lordship, this is the case in connection, bail in connection appeal. Lordship, in the
In one matter,
evidence.
bail was granted by the court, coordinate bench of this court. But till
No, there is no bail.
No, yesterday or day before yesterday, we took up in one matter where despite the bail order, he was still in custody.
No, this is not a case.
It's not that
This
case.
is-
We had asked the learned advocate appearing for the legal aid, what he has done. Okay, so these are not the.
No, this is not the same case, my lord. This is absolutely a different case. There is an eyewitness, saw the incident, and
Who is appearing for the legal service?
In item number 5, I am okay. Item number. I was given appointment today.
There is a pending bail application.
So I have.
Yeah, bail.
I have not given any paper books or same or anything.
Learned advocate, who is appointed by the Calcutta High Court Legal Services Committee, Jalpaiguri, is present before this court to represent the appellant in this case. State is represented.
Yes,
It is
sir.
submitted by the learned advocate for the appellant, that presently he has no papers to conduct the case on behalf of the appellant. Paragraph. Department is directed to hand over the copy of the paper book to the learned advocate, who is appointed by the Calcutta High Court Legal Services Committee, Jalpaiguri, in the meantime. Let the matter appear in the list on 16.
My lord, this week, Lordship.
16.
Upcoming.
16.
Lordship.
Whether I will have my appointment.
Why are you asking us? Why are you asking us? You have not seen the court's order.
I authorized the paper.
Call the next case.
Item number 6.
I am appearing for the WPSCDCL led by Mr. Madhusudan Sahara. He is
In this
appearing
matter, I
on
am appearing for WPSCDCL. I am appearing for WPSCDCL. On the last occasion, your lordship was pleased to direct the WPSCL advocate to place the policy before your lordship. On the last
Yes.
occasion, the report has been filed. And on that basis,
Yes,
in the
yes.
report, it has been specified that there is no negligence on the part of the WPSCDCL as per the version of the local people. Now, it has been fallen from your lordship. What is the basic policy? What is the basic policy? Now,
Yes.
kindly see the policy which I am placing before your lordship. But this is the policy which is handed over to your lordship. That is the 17/3/2017. Lordship got that policy?
Yes.
Lordship got that policy? My lord?
Yes, we are looking at it. Just give us 2 minutes.
Yes, yes, yes. Yes, yes. I'm grateful, lordship. In the policy, kindly see in supersession of the office order dated such and such. In supersession of the office order dated such and such. The office order here. Kindly see the serial number 1. In case of death, the quick compensation is 5 lakh. Apart from the other parameters, lordship. Now, this is the basic policy which has been followed by this Calcutta High Court in several judgments. Now, in a one decision which I am placing before your lordship, that is the judgment in Rima Shah versus State of West Bengal. Lordship got that judgment,
Yes.
which has been
Where is
passed
it?
on 19th February 2024. Lordship, this judgment is also pertaining to electrocution, and here there is a dispute, there is no negligence. The court finds that there is a dispute as to whether the authority is at all liable for that. In paragraph 24, I am drawing your lordship kind attention to paragraph 24 of that judgment. In such view of the matter, insofar as the writ court is concerned, there is a prima facie evidence of the victim having been died of electrocution. But as regards the negligence or liability on the part of the distribution licensee and the entitlement of the petitioner, if any, to compensation from WBSCDCL, the matter has to be
Please
decided
allow us
before
to
the
read.
competent civil court.
Allow us to read.
Lordship. I'm sorry, lordship, I am not audible. I tender apology, lordship. Probably 3 judgment has been placed before your lordship. 2 division main judgment is also placed before your lordship.
You have no patience, sir. Yes, which other judgment?
Lordship, this is the single bench and two judgment which I am placing before Lordship, division bench judgment. Here, there is a iota of negligence on the part of WBACDCL. So based on the policy, 5 lakh compensation has been granted as an immediate relief. If your Lordship kindly see, the order passed on 4/8/2020, that is on, Lordship will find that is on by the Honorable Astral Chief Justice on 23/8/2023 WBACDCL versus Raju Sheikh. Lordship got that judgment?
Yes,
WBACDCL
please
versus
allow us
Raju
to
Sheikh.
read. Please allow us to read.
Lordship. Lordship. We cannot view your Lordship. Some technical reasons subject to Lordship. I cannot see.
What the single judge has directed? There is an order.
Lordship,
What is that?
Single charge is directed to go before the appropriate forum.
Yes, what do you want to say?
May I submit subject to lordship and approval?
Yes, yes.
So on the based on policy, the Honorable High Court, single bench, as well as the division bench passed the order. And so far the negligence is concerned based on the report lordship, inspection has been made, and your lordship will find that on the basis of the version given by the local people, that there is no negligence on the part of the WBSCL authority. There is a unauthorized interruption on the service of WBSCL, and for which this mishap has happened. Now, lordship will find that single bench has rightly passed these decisions that if there is any dispute, the matter ought to refer to before the civil court, lordship. And this policy has been implemented where it is found that there is a negligence. As an immediate relief, 5 lakh compensation is granted in case of a mishap, in case of a death of any person. So, lordship, my humble submission before your lordship, based on this policy, as well as the decisions given in this Rima Shaha case, my respectful submission before your lordship, the appropriate remedy for the petitioner or the appellate is to avail the remedy before the civil court, lordship, because evidence is required, lordship. And so far the evidence, adducing of evidence cannot be gone into with deepest respect before your lordship by this writ court, lordship. This is my respectful submission before your lordship. Lordship, I cannot see because due to some technical problem, I cannot see anything. Nothing is visualized.
Camera is not working.
I'm sorry for that. Probably I am visualized before lordship, but this court is not visualized before.
What is the date on which the electrocution has taken place? What date? Yes.
Lordship, with respect to negligence, if Lordship may see the police report submitted by the state. Lordship can see that
Where is the police report?
the state has video by.
Which page? The report is at which page?
Lordship, page 18 of this. Lordship, you can see in the second paragraph after point number 24. There has already been an instance where the wire from the two poles, one old and one new, has snapped and already burned someone else's house.
So what is the manner of electrocution? What happened according to you?
Lordship, so
What is your version? Where is?
my lordship is that the petitioner's husband got that because of the wire having hanged loosely between the poles. The petitioner's husband came in contact with the wire and got it. And lordship also has page 20 of the same report. Police records that there is no mention in the departmental inquiry about why the old pole and its connected wire were not removed after installing the new pole. Lordship, that establishes negligence on part of SCDCL. And despite verbal complaints made by the residents of the village, Lordship station
So
man,
their new pole was installed, but the wire was not shifted on the new pole.
Lordship, there was wire hanging across from the old pole to the new pole. And also, Lordship, the station manager, there have been a lot of verbal complaints against the said issue, but the station manager now is absconding, Your Lordship. That has been recorded in the state's report also, Lordship. If I may direct page number 3 at para 8. Last sentence.
May I submit? May I submit?
How can we be certain that this state is without taking effects?
You have the single judge judgment of this case. Raju Sheikh,
Yes, Lordship.
the single judge judgment.
No, Lordship, the single judge order is not.
Because the facts are not considered by the division bench, it has relied upon consideration of the facts by the single bench. So what is the fact? Let us see. There is a
Lordship, may I
finding.
find it from the?
Yes, please. Is there a finding regarding negligence?
There was no written complaint placed before the authority. And there was an unauthorized interruptions in the electric service, Lordship.
There is a written complaint lodged by her wife.
Hindi.
Lordship, page 33 of the petition.
Same as page 15 of the opposition.
Yes, Your Lordship.
It's a high tension wire.
Yes, sir. 11 kilo.
That is not carried directly to the domestic outlet.
It's a high tension line. It has been made for public interest, and it is almost away from the any authority, local people, Lordship. And unless it is unauthorizedly interrupted, there is no chance of accident. And so far the complaint is concerned, there is no written complaint placed before the authority. Not a single document has been produced by the petitioner that the complaint has been made. In spite of the written complaint, no steps has been taken. And even the local people has admitted that there is an unauthorized interruption of the service by this person, Lordship. And for this mishap has occurred.
Only one person. Not many,
Lordship.
just one person, his neighbor. His neighbor's statement has been recorded by your officer, some officer.
Yes, yes. And your Lordship, under section 161, section 161 of the Electricity Act, subsection 3, provides the civil court power to the chief electrical inspector also. And since there is a disputed question of fact, I beseech before your Lordship, this matter is to be resolved by the civil court, Lordship, because the evidence is necessary, Lordship. Not a single document has been produced that a written complaint has been given. On that pretext, no step has been taken. And this report has been filed by the concerned station manager. Even the division bench repeatedly held, in case negligence is proved, a compensation based on the policy immediately is 5 lakh rupees. But if no negligence is proved, as per the judgment in Rimasha, it has been specified one has to go before the civil court. this order has been passed by the learned single bench also, which is subject matter of challenge before your lordship. My humble submission, there is no infirmity or illegality in the order passed by the learned single bench.
No, Saha is single bench. Your Rima Saha is not a division bench, it's a single bench.
No, it's a single bench, lordship. It's a single bench.
Yes.
It's a single bench, and the division bench clearly specified based on the policy where there is a iota of negligence, 5 lakh rupees, immediate compensation is to be given.
Where is
And
that?
if-
Where is that? Read that
Lordship,
from the
lordship.
division bench.
Yes, lordship. I'm
Yes.
showing to lordship. May I place it?
Yes.
That is the division bench. One
Which
is
judgment
that
you
is
are
which has been
reading?
passed by the, I am reading Raju Sheikh judgment, lordship.
Yes, where does it say about negligence?
Now, it has been challenged where the Honorable First Court has specified where there is a negligence on the part of the authority. So the compensation should be given based on the Motor Vehicles Claim Act, lordship. The division bench, if your lordship kindly come to.
You just now submitted that the division bench said where there is an element of negligence as per policy compensation should be paid. Please read that from the division bench
I am
judgment.
saying that
Please read
kindly
where
come
you
to
have found
paragraph
this.
2 of the Raju Sheikh.
Yes.
After elaborating, considering the submission made on behalf of the learned counsel of the party and your view that the order passed by the learned single bench holding the writ petition is eligible to get compensation for death of his minor aged about such and such who died due to electrocution, the reason assigned by the honorable bench are perfectly just taking note on the fact of the circumstances of the case and the
Sir,
same
we
does not
asked you just
call
to
for.
read, you made a specific submission that the division bench held that where there is element of negligence as per policy compensation is to be
No,
paid.
I am saying
We
lordship,
don't find that, so we asked you to read.
No,
We
lordship,
don't
subject
find
to-
that in the judgment.
Lordship, in the single bench, it has been held that the compensation should be granted as per the
Make
motor
such
vehicles
submissions which
compensation.
are contrary to record. That is not appreciated.
Lordship,
When
I'm
you
sorry,
make a
lordship, but
specific submission, then you should be sorry. Yes.
lordship, I'm sorry, lordship. But here it has been held that we are of the view that directing the multiplier method, which is applied while assessing the compensation
That's a different.
under motor
That is a
vehicle
different issue.
compensation to be adopted by the lordship. Lordship.
The state government directs.
Executive.
This inquiry committee is constituted by the appropriate government.
Yes.
Where is that? From where do you say yes? Your argument is that this finding is equivalent to a finding of a civil court because it is covered by 161. 161 talks of constitution of a committee by the appropriate government, then only. So was this committee constituted by the appropriate government? And that also has to be constituted if there is a public hazard, not in an individual case. So where is that fact? It's not there. 161 says an appropriate government may, if it thinks, require an electrical inspector or any other person appointed to inquire and report. So therefore, this authority can be vested by the appropriate government. Appropriate government is defined in 2(5). It means the central government or the state government. So unless there is such a direction or authorization by the government, how can you rely on any report that any officer submits in an individual case? Strict liability concept will apply to you. You are the, you
Lordship.
have been maintained. So there is, that is, and we don't
Lordship,
find
kindly
that
see in
has recorded any negligence on their part. It's not a question of negligence. There also the same plea was taken. This policy does not even use the word negligence. That's why we wanted you to place the policy. The policy is similar in every state. It says in case of an accident, there is a liability which is taken up by the corporation or the company itself. Beyond that, if they want to establish a negligence, then of course they can go to the civil court and get a compensation higher. And if they fail, this is the maximum they will get. But it does not say that
Lordship.
negligence has to. It says out in the event of death or injury caused by an accident. That's all. It does not say that
I
in
bow down
case
to your
of
lordship.
negligence.
I bow down to your lordship. I bow down to your
Anything like
lordship
that.
view because it is. I bow down to your lordship view that immediate compensation for such mishap is the 5 lakh rupees, and if he
Yes.
wants further compensation, he can go with that. I bow down to your lordship.
Yes, that is
I
what
bow
we are
down
saying.
to your lordship view. Lordship.
Beyond that, we are not going to allow.
Lordship,
anything.
since it is not visualized, so I can't quote before your court. I'm sorry for that, Lordship.
No, we are also sorry because we
I
are told
tender
by our
apology
system
for
person that we are relaying the virtual thing, but we don't know why you are not getting it. There is any problem here? No,
but
there is
I
no
am not
problem
getting
from our
that.
side.
Anyway,
Probably
Lordship,
you have a
anyway,
weak.
Lordship, I can.
You probably have a weak internet connection.
Probably, Lordship.
Yes.
I tender apology for
Point
that,
of,
Lordship. I tender apology for that. Lordship, kindly pass the necessary order on that basis.
Just
Based
a
on
minute,
the policy.
let us. What is this for?
Lordship, this is a judgment, Lordship, just a second.
Have you given them a copy?
Oh, yeah, Lordship.
You can rely on it. Give them. It's not a reported judge. Give him.
Lordship, I don't have any other copy with me.
Then
Unfortunately.
how can you rely on it? Either it is a citation, then you can share, or you have to give a copy. How they will know what you are talking about? Give him a copy. We'll pass the order tomorrow. For further consideration, list tomorrow at 10 a.m. at 10:30. At the top. Yes.
Lordship, can it be on Monday? Subject to Lordship kind
When you are-
approval.
When you are appearing virtually, how does it matter whether it is Monday or tomorrow?
I have got one fixed matter in the top in the morning tomorrow. Subject, if Lordship permit me,
Then tomorrow-
it will be.
tomorrow-
I am
tomorrow at 2
grateful to
p.m.
you, Lord.
We'll take it up at tomorrow at 2 p.m. Yes.
As your Lordship, please. As your Lordship, please. I'm grateful to your Lordship.
My lord, item number 7, my lord, I appear on behalf of the petitioner, my lord. My lord, yesterday what had fallen from your lordship was that since the tribunal, my lord, a notification for constitution of the tribunal has been issued, I should move the tribunal. But my lord, my predicament is that, my lord, the learned single judge has given certain observations against me. My lord, in my limited understanding, my lord, a tribunal subordinate to a constitutional court, my lord, perhaps cannot reverse the findings of a constitutional court. So, my lord, on that count, my lord, perhaps my remedy lay before my lords. My lords, am I audible, my lords?
Yes, in which paragraph there is a finding?
My lord, kindly takes, my lords.
Oh, this is on condonation.
Yes, my lords. My lord, kindly takes paragraph 11 of the judgment, my lords, of the learned single judge. My lord, may I place, my lords?
Yes.
Paragraph 11 says that the reasons which have been tendered by the petitioner before the authority concerned were not appropriate. That is why delay
Then
could
what the
not.
tribunal will do, he is correct in that.
But that has to be set aside and my lord can remand it back to the tribunal. My lord may set aside the order of the honorable single bench and my lord may remand back the matter to the
My lord.
tribunal for the under section 112.
Otherwise, what is the law? Let us see when the judgment of the single judge is there. Then if we find that it is not correct, then only we can set it aside.
Yes, my lord.
We can't set it aside only for relegating.
That is also true.
Unless we give a finding, return a finding that is not sustainable. If
But
we
this is-
give a finding that is not sustainable, then what is the point in sending it back?
My lords, I am grateful, my lords. My lords, this is, my lord, my lord, there is a provision under the GST Act for preferring an appeal before the appellate authority from an order of the adjudication authority, my lord, within a period of, my lord, outer limit of 4 months from the date of
If we
community.
remember correctly, the provision also circumscribes the limit to which it can be
Yes, my
condoned.
lords.
Yes.
Yes, my lords, 4 months, my lord. the outer-
Perhaps 90 days or 30 days, something like that.
It is 90 days plus 30 days.
90 days plus
90
30
days, then plus 30 days,
So
30
altogether
days.
4 months.
Altogether
Just
4 months. 30 days is the discretionary.
Yes, my lord. But
Period
my lord,
allowed.
the relevant thing in my case is that, my lord, the date of communication, the date from which the limitation will start to run. My lord, to that effect, my lord, there are several judgments of our honorable court, including a division bench judgment, which says that uploading.
Where are the judgments?
My lord, I'll urge my learned friend to hand over my lord Ram Kumar Sinhal. My lord, it's reported at 2025 ACC Online Cal, my lord, page 6279.
Copy.
Page. My lord, kindly takes paragraph 45 of the judgment, my lords. My lord, in fact, paragraph 46, my lords. My lord, may I place, my lord?
Just give us. Yes.
Yes, my lord. So, my lord, the conclusion is that, my lord, the uploading on the additional tab does not constitute, my lord, proper communication. So, my lord, if I have
Yes.
not been communicated on the date of issuance, my lord, the limitation will not run.
In your case also, it was uploaded on the additional
Yes,
tab.
my lord, I'll demonstrate, my lord. Kindly takes, my lord, page 82 of my stay application, my lord. I have video screenshots. My lord, and in fact, my lord, from its inception in 2017, my lord, the GST portal has periodically been overhauled. My lord, at the relevant point of time in 2023, when the show cause notice was issued, this notices and orders tab and additional notices and orders tab as my lord notices was not side by side. It was completely separate. And now, my lord, only recently in February 6, 2026, the entire additional tab has been removed. And my lord, everything has been merged into notices and orders. My lord, pursuant to directions in this, my lord, the reported judgment. So, my lord, in 2023, when I was served with the show cause notice, my lord, it was only additional notices and orders tab. My lord, on that count, my lord, my contention is that there was no proper service upon me, and my lord, the proceedings on that count are vitiated.
No, there is a specific case in the case of Ram Kumar Singhal that it was not uploaded on the first notice tab. It was uploaded only on the additional one.
So, my
Where
lord,
is that factual premise laid down by you in your writ petition? Where is that averment? Let us see.
my lord, in my writ petition, my lord, I had said that, my lord, there is also an additional fact that the proprietorship is in the name of a wife. My lord, the husband used to
Sir,
run.
additional comes after the first. So don't jump from the first point.
Yes, my lord. My lords. Lords, I'm sorry.
Not there. In the writ petition itself, that ground has not been taken by the.
Let's see. Let him make up.
My lord, kindly takes, my lord, page 6 of my lord stay application.
Where is your writ petition, sir? Why we should look at the stay application? Where is your writ petition?
The writ petition starts at page number 23 of the stay application.
Yes.
21 rather of the stay application synopsis. Then, my lord, the original statement.
It's not legible. What kind of copy you have?
The statements start from page number 28.
My lord, page 29, my lord, of the writ petition, my lord, takes.
Yeah. Page 29 is the second page. Starting from paragraph number 3.
My lords, from paragraph 7, my lord, have laid down the facts.
रीटे प्रिंसिपल ऑफ नेचुरल जस्टिस अभी लिखी नहीं, ठीक है।
These judgments were not considered by the single judge.
No, my lord, maybe, but the fact remains that, my lord, it was written in the judgment passed by the learned single judge that all this time the SSC was filing returns. So it cannot be said that he was unaware of the entire orders that have been
in
passed
Ram
against
Kumar
him.
Sinha
He was
also the
filing
SSC was all
returns.
the while
That
filing
has been
returns.
reflected in page number 75 of the order impugned.
All this while when you were making submissions, he was just listening to you.
My lord, I'm so sorry, my lord.
You think it helps by making a voice over
No, my lord.
voice?
My
You
lord,
think
I
we
apo-
can appreciate anything by doing that?
My lord, I apologize, my lord.
Yes.
My lord, in page number 75 of the impugned judgment,
Yes.
my lord would find in paragraph number 11,
Yes.
it has been specifically stated in the judgment impugned that in the middle part, if I may read my paragraph number 11, my lord. It is contended on behalf of the petitioner that due to informal separation between the petitioner and her husband, compelling the petitioner to stay separately was the main reason for causing delay in preferring appeal.
That's
But-
right. So
Yes, but it needs to be taken into consideration that at the relevant point of time, returns were filed. Therefore, it
Alright.
ought not to be inferred
we are
that an
not on the
SSC.
various other.
Yes,
This
was
is
filing-
one- This is the one transaction. which
Yes,
is in
he was
issue.
already filing returns.
So this is the only transaction which is in issue, whether the others were being filed by the earlier caretaker, all that has not been
Yes,
gone into.
yes.
We don't know.
Yes,
So the point is whether there was a proper notice in the first tab or additional tab, these judgments has not been considered.
no one.
So for a consideration, like you said, it can be remanded to the tribunal.
As my lord
And we
desires.
can say that this finding in paragraph 11, since it relates to the other returns, it will not act as a prejudice against the petitioners present.
But it relates to the petitioner itself. He was filing it does not relate to the return in question, but it relates to subsequent returns which were filed by the SSC.
Maybe, but let's see. We may be able to make out a case between, because all this will be considered by the tribunal. Yes, yes.
Yes, my lord, if I may submit, my lords. In fact, my lords, in Ram Kumar Sinha, the SSC was filing returns as because, my lord, the GST Act
All
provides.
right, you have not heard what we just observed.
My lords,
What do you want to say after that? After that, what do you want to say, sir?
my
We are
lord,
saying this finding in paragraph 11 will not prejudice you before the authority. What more we can say?
yes, my lords, I'm
It will
grateful.
be open to you to show this individual non-filing within time. The others which have been filed, whether that can lay the premise of a presumption or not, we are not going to. Yes. It is an admitted position between the parties that the tribunal is now in existence. And therefore, the issue is now to be considered by the GST tribunal. Stop. The learned advocate representing the appellant, however, does not, without disputing such submission of the learned advocate for the respondent authorities, submits that the findings contained in the order in the judgment dated 28/7/25, under appeal, may weigh in the minds of the authority. Weigh in the mind of the authority to which the matter is to be relegated. Full stop. We appreciate such apprehension being raised by the learned advocate for the appellant, which is founded on observations of the Honorable Single Judge in the judgment, specifically in paragraph 11. Stop. Another aspect which we would like to observe is that the petitioner, that the writ petitioner's case with reference to decision of the division bench of this court in the case of Ram Kumar Sinhal versus the state of West Bengal and others was also not considered by the Honorable Single Judge. The issues, therefore, if relegated, are required to be considered on a clean slate. In view thereof, we relegate the matter to the, we allow the petitioner to avail the remedy of appeal before the GST tribunal. Full stop. The order of the learned single judge, in view of our above observations, is set aside to enable consideration of the matter of fresh. Full stop. The appeal is disposed of in these terms.
Grateful.
Grateful, my lord.
I am for the appellant, your lordship. Or I am for the state, led by Mr. Rai. Lord, impugned order dated 16 February 2026, your lordship. Page number 83, your lordship.
Yes.
Yes, your lordship. In this petitioner case, your lordship, in land acquisition case, your lordship, there has to be award.
Why after 40 years? Source from your reflection. What have you said? Why after 40?
40 years, your lordship. It is my petitioner.
Show from the repetition what you have said.
Page, your lordship. My lord, para number 2, your lordship. Page number 5, 25, your lordship. In writ petition, page number 5, your lordship. In appeal 25.
The application 20.
In 2020, record of rights has been created in the name of the present petitioner, your lordship.
Cannot be.
There is nothing about this. It has nothing to do with company.
Delay part. Regarding a delay, I could not make any could not make any statement, your lordship. Because earlier, my father's land has been acquisition in 1978, your lordship. Then after the 2020, the record of rights in that plot of land has been created in my name, your lordship.
Cannot be.
State council. A writ petition is filed in the year 2025. Seeking enhancements through the revision of the compensation eligible paid to the successor. It is
Item number 9.
Let's appear for the petition. I'm for the CGST.
Yes, sir.
Lords, this appeal has been preferred against the order passed by the learned single judge dated 11th February 2026, whereby my writ petition challenging the cancellation of my GST registration was dismissed, and I was relegated to the appellate authority, my lords.
You don't want to go to the appellate authority.
My lords, my case is covered by coordinate benches, division benches of this court.
Therefore, the appellate authority cannot consider that aspect.
No, my lords, it can consider.
Right?
But my lords,
Is that it has to be done by the High Court, so there is a statutory.
my lords, this
What are the circumstances in which the law permits you to avail such a remedy when there is an adequate, efficacious statutory remedy?
my lords, but this is my fundamental rights. This is a civil death penalty imposed upon me. my
Nothing.
lords.
Heard the learned advocate for the appellant. Stop.
May I place my case, my lords?
Nothing, sir. What will you place? We are not going to hear it on merits.
But my lords, one thing, just one
Yes,
point.
yes.
My lords may send me back to the appeal.
We are not sending you back. You have already been sent back.
My lords, just one thing.
Yes.
This single judge, my lords, in the order has recorded that there was a case pending against me. That was the reason for denying me the relief.
Yes, where is that?
My lords will.
Criminal proceedings are pending.
Yes. This was the reason for denying me the
Evasion
relief.
of tax of
Now
more than
this-
10 crore.
Now, my submission is that, my lords, this point has not been, this point does not, is not recorded in the cancellation order or in the show cause notice. This is an extraneous circumstance.
That's what will happen when you come to these forums.
My lord,
You will
cancel.
enlarge the scope of everything.
My lords, but
See, that is, you should realize why you should have preferred that remedy.
I bow down.
There
lords.
would have been nothing beyond what was there in the uploaded portal or regarding
I bow
whatever.
down, lords, but it is settled
Cancellation
proposition.
order.
My lord knows better that
Cancellation
lords,
order.
reasons cannot be supplemented in the orders, my lords. Because this was a submission made by my learned friend, which was impressed by the learned court, my lord.
Let us,
My-
let us just.
If my lords want, I can show you.
Just wait. Already stated, the observations are not restricted to this one.
Just one thing, my lords.
Shall not prejudice. What more can he say?
My lords, may I submit? Just 2 minutes, my lords, bear with me. My lords, the act provides a time limit of 270 days, which is 90 plus 180 days to prefer a revocation application against the cancellation of registration. My lords, I filed my revocation application.
We are
On
not
the
hearing the
127th.
matter on merits.
I'm not on merits, my lords.
You are traveling on merits.
I'm just
You are
stating the
trying to
facts, my lords.
justify the non-filing of returns, or you are trying to unjustify the revocation or removal.
They have rejected my
We are
revocation
not
without
going to hear. You
considering
may
anything.
try, we will not go into that.
Very.
Yes, heard the learned advocate for the appellant. Stop the writ court.
I'm great.
I got the zero.
Keep it.
Yes,
CRA 45. All tables. Two sets. Three. Item number 3.
Thank you.
Item number 10.
Same, I'm for the petitioner, Lordship.
Full statement.
This is a delay of 36 days. The delay may be control, Lordship.
Yes. Can one,
Can one.
what is the main issue?
Lordship, the petitioner applied for the fair price shop and his application was not considered. And
Yes.
on the ground of that the petitioner do not comply as according to the notification.
Yes.
And on that relevant point, only 2 point is the petition was dismissed. That is, as per the as the state was directed to produce the relevant documents, relevant record, the relevant record was not given to the petitioner to place his case and to object any perversity of the record.
Where is the writ petition? Writ petition. Yes, what did you say? What was your allegation in the writ petition? Read it.
Lordship, my
Why you have wrongly been excluded from the process? Why? What have you said in the writ petition?
Lordship, the state was directed to produce the relevant
We are
record.
not asking what the court directed. We are asking you what is your case? Why the rejection is wrong as per your amendments made in the writ petition?
Lordship, as per the petitioner's concern, he is completely capable to apply the as per the notification of the respondent. And
You say you are competent, you possess all the requisites.
Lordship,
They say you don't possess the
Lordship.
requisites. This is the only issue.
Lordship, that is the issue.
Yes, take down. Heard the learned advocate for the appellant. the can application seeks condonation of delay of how many days?
36.
36 days, comma, the office however has reported
Minor in item number 11. One sec, item number 11. My lord, in item number 11, my lord, the advocate on record is supposed to be undergoing surgery within this week, my lord. I'm praying for next circuit.
Mr. So and so, give your appearance.
Yes, ma'am.
And so appearing virtually submits that the learned advocate who is to conduct the present appeal is likely to undergo a surgery in a few days. Full stop. Prayer is made for adjournment to the next available circuit. Full stop. Matter stands adjourned accordingly. Yes, the learned advocate for the state.
Grateful.
Grateful, lordship. Grateful.
Grateful.
Grateful. Item number 12.
Lordship, in item number 12, I am for the appellant, your lordship, led by Lane DSG. Lane DSG come. Lordship, this is the matter. The writ petitioner is a enlisted contractor under the MES, your lordships.
MES.
I mean, Military Engineering Services, Union of India, your lordships. Now, we received the input from the CBI, your lordships. The CBI laws and one FIR on the corruption charges for procurement of the tender process in Lakshadweep.
In
Lakshadweep, your lordships.
Lakshadweep.
Lordships. Enlisted contractor are eligible to participate in all over India, your lordships.
So enlistment is countrywide.
All this, yes, lordships. Now, given the so-called notice, your lordships, after the inputs, they replied. Now, after reply, consideration of the reply and rules, the authority issue a suspension of business for 1 year's order, your lordships, during pendency learned DSG.
Yes, 1 year suspension. Then
My lord, then after that, this suspension order was challenged.
1 year suspension is dated.
My lord, it is,
Suspension order.
my lord, we
10
find
আর
it
12 10 and 12.
73.
হ্যাঁ ওটা হবে
19th July 2025.
10 11 P1.
Yes. So that is the,
Only, my lord, suspension means dealing, business, suspension of business.
where is that order? Let us.
My lord will comes to page 73 of our stay application.
অথবা 10 11 পেজে আছে স্টেটে স্টেট 10 11 পেজে 10 11 suspension P1.
And it is also annexed as P1 in page 10 of that stay application. Same letter, my lord.
সেম ওরা রিটে লাগিয়েছিল আমরা আমাদের স্টেটে আলাদা করে লাগছে কিছু পার্টিটা তোমাকে দেখিয়ে দেবে এই কথা বলেছি হ্যাঁ বলেছি
Where is the enlistment letter?
দিও
My lord, the enlistment matter was not filed by the petitioner due to the
এনলিস্টমেন্টে করেছে
আছে তো কি বলছো?
change of constitution.
Enlistment letter was not filed.
Yes, yes.
No, my lord, that is a change of constitution is there. I did not find, maybe Mr. Roy can assist.
Yes,
the board in
yes.
that way.
Where is the enlistment letter?
First, মানে কাছে page 48, 49,
My lord,
or
this is
sub, and then is a renewal at page 50.
We are asking you, where is the enlistment letter?
Can you page 48, my lord?
That's not an enlistment letter.
This is my lord, they have said. Can you come to?
This is, they have said, you have to say what they will say. We
They-
ask you X, you say Y.
No, my lord, I'm not saying, this is they are in their formation, this is the enlistment letter. Can you see? I know your lordship would be this question.
This is a change in constitution of the firm.
Yeah, but this is, they say the enlistment letter. In their order also they have written. And see, they have quoted the paragraph 9 of this, is 49 of this letter. They have given, suspend me in terms of paragraph 9 of this letter. At page 49, this para 9.
এই 2018 এটাই আছে লাস্ট, তারপরে এটাই আবার রিনিউয়াল হলো, সেটা পরে পেজে আছে, এটাই আছে।
আরে না, enlistment come.
প্রথমে enlistment
Taking
পরে
this,
change of
sure.
look add করে দিয়ে এটা দিল।
Page 49.
This is clause 9 of this document. has
Yes,
been
yes, they are
referred.
considered.
So this is not the enlistment.
I know, but they say,
But they have referred, so you should say that this is the, not the, but this has been referred by them.
yes, ma'am.
This
They
is
have,
not the enlistment letter.
My lord, the original enlistment letter is dated 13th February 2006.
No, but in your,
My lord will kindly comes to the references A,
sir,
Page
kindly
48.
see paragraph 2 of the order impugned.
my lord.
Paragraph 1 of the order. 2, sorry.
Learned counsel appearing.
Impugned order passed by the Major General Chief
Lordship.
Engineer.
Page 73.
Page 73, just now you have shown us.
My lord.
20th January 2018. Para 9 of 20th January 2018 means page 49.
That's it.
That does not mean, that is not referring to any other document.
Change in constitution.
9টা রেফার করা হয়েছে।
And my lord refers to paragraph 2 of that letter.
Yes, sir.
In change in constitution of a firm.
You have page 73.
73
Reply submitted.
Yes,
Reply submitted video letter referred at para 1B has been examined in this HTU. Your reply is not found convincing at all.
in this connection. Now read from in this connection.
In this connection,
Yes.
please refer to para 9 of your enlistment letter dated issued by 20th January 2018.
This is at page 49.
49
Yes, my lord.
This is at page 14.
Absolutely correct, my lord.
হলো নাই।
Yes.
None of like. My lord, kindly takes page 48.
Suspend page 48.
This 13th February 2006 is the original enlistment letter.
Maybe, but you have referred to
Yes,
para
ma'am.
9 of this document.
প্যারা 9টা এখানে আছে, এইটাই।
And now, my lord, para clause 9 is this. Please note, MES authority has the right as he may decide not to issue tender form in any particular case and also to suspend, remove or blacklist your name from MES list of contractors in the event of submission of non bona fide tenders or for technical or other delinquency.
আদার ডেলিভারি ওটা।
So under the other delinquency, he was suspended, business was suspended for 1 year.
64 পেজটা না। সিরিয়াল লেটার।
One of the crux of the problem rose when CBI lodged an FIR against these farms. And wherein this part, they were found a money trail was found under Prevention of Corruption Act.
64 page 64 আগে সিরিয়াল লেটার।
Lordship will find the FIR lodged by CBI at page 64, typed copy.
এই জায়গাটা আছে।
Oh, this is an interim order.
Yes,
Uncontested.
My lord,
they have filed the opposition, my lord.
Now filed.
Yes.
You have filed the
No, my
opposition.
lord.
Yes, yes. I'll file.
Please, affidavit has been filed.
Completed.
No, my lord, the problem is this, in spite of he being named in the FIR, we have to allow him to participate in the.
You have,
Wait, this is not,
you have to. What is the option? Anybody is named in an FIR, he is.
No, no, my lord, not named, but there is a specific allegation against him in the FIR.
In every FIR, there is a specific allegation. But nonetheless,
my
it
lord-
remains an
my
FIR
lord,
only. It does
kindly
not
appreciate.
become, it does
My lord,
not,
kindly
it does
appreciate.
not become an order of conviction.
No, my lord, it never becomes an order of conviction, but prima facie, some.
So this is a
Material
prima
is
facie
informed.
finding. It is subject to what the honorable single judge may finally decide. We don't know. We don't want to judge that issue at the present. He has found it to be a prima facie ground for staying the order. State it. We don't find any infirmity because that clause 9 does not apply.
My lord, the clause 9 has a word delinquency,
Yes.
and the clear allegation is that he.
What is the definition of delinquency? Show us definition of delinquency. Which definition of delinquency
My lord.
covers being accused in a criminal case as a delinquency? Show us.
My lord, delinquency, if I am supposed to do something, I do not do, that is a delinquency.
There is
If-
not, see, these are hypothetical submissions. You
No,
don't
no, my
allege
lord,
that he has
we are
not,
supported by rules.
you don't say in the order that he has not done anything properly. You read the order again at page 73, what you have said.
Your firm has prima facie been found guilty of adopting unethical practices. Now, my lord, as per the rule.
Where is that finding of guilt? Where is that finding of, from where you have recorded this?
70 তে শো কজ আছে, ওটাতে ডিটেইলস দেওয়া আছে তারপর শো কজ।
Where is this finding of guilt? If there is a finding of guilt, then you should blacklist him. Why suspend?
My lord,
Why suspend for 1
inquiry
year?
has been initiated against the firm.
We are not on that, sir. This is a document which is calling for consideration before the court. The document says you have prima facie found guilty. We don't know.
My lord,
There is nothing in the
my
order.
lord, if I am permitted to draw an analogy. In a criminal proceeding, first of all, my lord, this is administrative proceeding.
This is an interim order, go and contest it. How would it be, it stays for how long?
these are 3 days, 3 weeks extended, my lord.
Huh?
Next week after this.
When it is fixed for consideration.
This is what,
You have filed your reply.
no, I'll I'll file, but I'll make it ready. Tomorrow I'll file. So, my lord, might be hard, man, no problem. No.
It cannot be had next week, is half of the week is, half of the week is holiday.
Well, they have filed the opposition into the extra few weeks.
You have not filed the reply.
No, my, forgive me, it's order. I'll file tomorrow. I'm ready, man.
You need an order to file the reply.
No, no. I say, man, this is my, I may be wrong, man. I file it tomorrow. I'll get the file
My
tomorrow.
lord, only on
What
the
has
ground
changed?
they will file reply, the interim order was extended.
I'll file reply, make it ready. Now, this is not a question. You are there, you are, did
the
you,
order
No, we
speaks
have to
so.
see everything, your bona fides also.
man, tomorrow I'll file the reply. I undertake it.
File it. Tomorrow you file it, you come back, we'll see. We adjourn the matter for further consideration tomorrow.
I undertake, I'll file tomorrow.
You come back after filing it tomorrow.
Yes,
Obliged, my lord.
at 2 p.m. man.
Obliged, my lord.
He's, they're asking for my card number. I'll find it. I'll make it ready. This is my fault, my lord. I suppose that today, tomorrow in the morning, I find.
He's very benevolent in admitting his fault and finding others.
My lord knows it.
Yes.
Item number 13.
Your Lordship, I am for the appellant. In this case, I am praying for adjournment. As the conducting counsel is coming from Calcutta, he is unwell, Your Lordship. So praying for kindly the matter may be fixed in the next circuit, Your Lordship.
That's great. List in the next.
Item number 14.
Nipta কোথায় আছে? ওর উপরে টাকা জিপটা দেবে।
14 হয়ে গেছে?
না না।
Appellant কোথায়? Well, I am for the respondent. My lord, it pertains to a service of post office. If my lord is kind enough to recall your lordship had passed orders in the old building, similar matter, CAT is the forum. And
extra departmental post, EDPO.
No,
Postal.
My lord, the only order that was passed by the honorable single bench was to go before the CAT.
Where is that judgment we had delivered?
Schedule court. My lord, we'll get it out, my lord. But my lord, the appellant is not there.
For the appellant, everything is on Friday. Please get.
My lord, will.
10.
Item number 15.
50, ma'am, for the suggest.
None appears for the appellant. List in the next.
Next circuit, my lord.
Wait.
Item number 16.
16 Lordship for the appellant led by Mr. Sanjay Mukherjee is on the virtual mode.
Item 16 is my appeal, my lord. The applications are for restoration and for condonation of delay. My lord, there are.
Which is the restoration application is CAN 2.
CAN 2 is the restoration and condonation is CAN 3, my lord. There is a delay of 219 days. I'll tell my lordship what has happened. This is an appeal arising out of a judgment and decree passed by the learned land acquisition judge, LA Judge, Darjeeling, in LA case number 43 of 1998, when the LA case had been dismissed. The appeal had been originally filed before the Honorable Principal Bench here, FA 96 of 2021. That got subsequently transferred, and in effect, it is our mistake, my lord. In fact, it is a change brief for us. But whatever has happened, my colleague there who was handling at that time missed it. And as a result, when the matter came up before lordship's coordinate bench on 3rd July 2025, it was appellant was not represented. Lordship, we have a good case to defend in this appeal. So if lordship kindly allows the condonation application as well as restores it and kindly calls the lower court records, and the paper books are required to be prepared. There has been an acquisition of 2.782 acres of land.
You have served a copy.
Yes, Mr. Pal.
My lord, in this matter, I am appearing for the state, my lord. My lord, I would like to use an affidavit to the application under section 5, my lord.
State will oppose my section 5 application. Will Lordship allow me to file a supplementary affidavit to put on record the facts which has actually happened, because there are certain facts which has not been stated either in my restoration or in condonation. I'll file the supplementary.
On the penultimate day you had, that day also you have not appeared. June
2020.
It was not the first listing, it was the
Yes, to file
second.
an application.
Anyway, we'll allow the rest.
Lord Lordship kindly allows it.
Can two mein likhna, an application for restoration. To stop the reasons for default in appearance stated in the application are found to be sufficient
I'm obliged.
for condemning, for allowing restoration of the appeal to stop. The learned advocate representing the respondent seeks and is allowed time for filing an opposition to Can 1, being the application for condonation of delay to stop. The opposition being filed will take into consideration the averments proposed to be made by the appellant in a supplementary affidavit, in an affidavit supplementing the Can 1, which
I'm
should be
obliged.
filed within a week from date. Let the affidavit in opposition be filed within 2 weeks thereafter. None.
May Lordship, one endurance Lordship in item number.
A list in the next section.
May Lordship in the item number 15, I missed the
I'm
matter,
obliged,
Lordship.
Item number?
15, Lordship.
What happened?
My Lord has fixed the matter next circuit, kindly not today, my Lord.
Not today. There was an adjournment sort of that.
I am the appellant, Lordship.
State was here.
No, Lordship, Union of India, Lordship.
We don't know if Union of India. You ask him to come, then we'll, otherwise we'll not. Please ask him to be here at 2 p.m.
Lordship.
Item number 17. 70, my lord, I appear for the plaintiff appellant. My lord, on 16th of March 2026, the Honorable Coordinate Bench was pleased to direct us to serve notice upon the learned advocates of the private respondents appearing in the learned court below, my lord. We tried to effect service, my lord. One learned advocate who was representing the respondent number 9 accepted the service. The other learned advocate who was representing the other respondents did not accept, my lord. May I file the affidavit of service?
It has earlier been served on the party also.
Yes, my lord. It was sent except, my lord, for one of the respondents, my lord. The affidavit of service as all service was effected, but it was running ex parte against them in the court below, my lord. They had filed their written statements, but thereafter, my lord, they did not contest. There is a delay also, my lord.
Condon.
No, my lord. There was a direction to file affidavits, my lord, on 14th of January 2026. Can 2 is the application for condonation of delay, my lord. State is represented.
The pro forma respondent, my lord.
Was stated reuse their written statement.
Yes, no, we are not going to file.
এখানে করবে তোমরা
Direction was given to effect service upon the respondents, not the learned advocates. That is
Yes,
their
sir.
order 6/1/2026 as it appears. Go through the order. Upon the respondents.
Yes, my lord. Affidavit of service was filed on 14th of January, my lord.
Service affected.
Yes, my lord, except one of the respondents. Thereafter, my lord, the further note direction was passed, directing us to serve upon the learned advocates
No, where is
appearing.
the order accepting the service?
My lord, on 14th of January, my lord, the affidavit of service was taken on record.
No, but there is no record that there is a service. The court has not recorded that the service is complete. It has only been taken on record.
Then, if your lordship so desires, my lord, I'll again effect service upon all.
Therefore, there has to be a record that there is a service or.
Yes, yes, my lord.
If it was found by the affidavit that it was acceptable, the court would have recorded.
I understand, I understand. Very well, my lord, if your lordship so directs, I'll again effect service upon everyone.
Direction should be given to effect service upon all the respondents.
Except respondent number 10, my lord.
You are representing which?
I'm representing the pro forma respondent number 11.
11, my lord.
State.
Other than respondent number 11.
Yes, my lord.
Appellant is
Service and affidavit of service will be enforcement.
Grateful. Grateful.
For the appellant led by Mr. He is appearing virtually also.
Lord, I am for the respondent, my lord.
Sir, kindly unmute, sir. Unmute kindly, sir.
Lord, on the
No, sir.
charge.
Am I audible?
Yes, sir. Shweta, sir.
Yes. Yes.
Now, my lord, I am appearing for the appellant, my lord. I have scanned to, my lord, seeking extension of the order which was passed on 20th February 2026. my lord, and one more without direction that let LCR be called for. Otherwise, this appeal, my lord, is
Appearance is complete.
challenging or-
You are representing.
Yes, my lord.
But I am for the respondent. Now, my lord, so far as the interim order is concerned, my lord, we have preferred an application seeking vacating of the interim order. And if my lord kindly takes that is can 3 in your lordship's file, and my lord, the entire records are annexed in can 3. The application, the written statement, depositions, cross-examinations, judgment, and all the order sheets.
No, my lord, all order sheets are not there. My lord, there are missing order sheets.
Let the trial court record come then.
Milord, if I may say this, Milord, let the trial court record comes, Milord, I have no difficulty. Milord, let the can 3 be, Milord, heard in case they want to prefer an affidavit, let that affidavit come in. So that the vacating can be heard.
All right, within the same time, they will file their response to can 3 if required.
No difficulty.
And there is a, yes. The learned advocate representing the respondent submits that an application for vacating the interim order is filed. Stop. Copy of the application can 3 is served on the learned advocate for the appellant, who seeks time for responding to the same. Stop. In the meantime, we find that based on a prima facie finding, the coordinate bench has passed an order dated
20th February 2026.
20th February 2026, staying operation of the judgment and decree for a period of 6 weeks, full stop. Under this above noted facts and circumstances, we deem it appropriate to grant time to the learned advocate for the appellant for using a response to the can 3 stop. Within a fortnight?
Yes, my lord, no problem. The fortnight.
The same.
Milord, I am also, Milord, praying an opportunity, Milord, to file an opposition to the stay application. Along with that is Milord, can 1.
All right. Then within a fortnight, full stop. This time may be utilized by the learned advocate for the respondent for filing an opposition to the stay application earlier filed. Stop. Let the trial court records also be requisitioned.
Well, let them deposit the special messenger cost. Otherwise, it will be, Milord.
The requisition be sent to special messenger. Stop. On receipt of the records, paper books shall be prepared. After verifying the records received. Stop. The matter is adjourned to be taken up after 4 weeks in the circuit available. Stop. In the meantime, we are of the view that the interim order dated 20/2/2026 shall continue to remain in operation till 15th of May. In the meantime, let us cover 15th of May or till further orders in accordance with law.
Much obliged.
Grateful.
Item number 19.
Look, item 19, Mr. Urup Chatterjee is appearing for the petitioner. My lord, due to his illness, he is not come. So next week.
What do you want?
Next week, Monday quiz.
First, Captain. Not serve.
Yeah.
How is the paper
Maybe if you
As prayed by the learned advocate, for the appellant, matter is adjourned for a week. So copy has been served. You are the only respondent. Copy has been served on the sole respondent.
It could be 25,880.
In the meantime, the appellant shall take steps for removing the defects pointed out.
Deficit could fee 25,000. Go through the report.
deficit fees. Deficit fees is deposited.
Nearly 26,000. Just see that it is deposited.
Everybody is getting. In our I thought we have seniors plant, I used to go to and then stamp reporter. One week or a last day. Next week. 16. This 60 will not be here.
Then Melody, next cycle.
Next cycle.
Next cycle. Yes.
I think 120.
I'm for the appellants. Lordship, kindly place the matter in the next circuit.
Why, sir?
Accommodations have been taken.
My senior is medical issues, that's why. Medical issues, that's why. Sorry, my lord. Some medical issues.
You are for the state.
They are paying for high scale of.
That's been rejected by the.
Yes.
What do you want? Why you are filed it if you are not interested in it? It's only a series of, it's only a series of adjournment. Why? Your senior is on medical leave.
Yes, my lordship.
How long leave he has taken?
Lordship, 1 week.
He has to be present before the board yesterday.
Ask him to be here tomorrow, not today.
Lordship.
Can you have taken a month? Read list on Monday.
Wait. Item number 22. This is an appeal, my lord. Last occasion. Unga.
22.
It's a matrimonial appeal, my lord. I'm for the husband. And the wife, there's some
Divorce has been allowed or rejected?
rejected. So now 498 case, I've been acquitted. So my new point, but last occasion, the division bench, ordinary bench, tried to settle the matters. So my lord, but the division bench asked them to go together, visit it. But my instruction that has been, it is in vain. So you also kindly give some time, I'll just talk with them whether,
There is an order to this effect.
well, yes, there's some order indication is there, but.
May I, Madam?
Yes.
Madam, myself and Mr. Navankur Pal were appointed mediators, Madam, by the Honorable Court.
That is earlier.
Earlier, Madam, in 31st of October 2025.
I am ready to do the matter, but.
Mediation has failed, we have filed our report, Madam.
And that thereafter.
Thereafter, my lord, can we be discharged?
No, what is the, by which order you were appointed as?
My lord, 31st of October 2025.
That was long time back.
And then, my lord, last
My lord,
order.
report has also been filed.
Well, they find that this mediation fails, thereafter the coordinate bench might try to settle the issue. That's the last order. Last order no release it's very bad.
Years.
I paid the maintenance, there's the three orders, order,
Age of the husband is about 60 years.
yes, yes. This is on the Bhaja retirement. And this is really very unfortunate, but.
Who is representing the wife?
Wife, Mr. Shatoki Basu will be appearing, Lordship, and please some personal technicality. Kindly keep the matter on next to Lordship.
Are you having any instruction whether the parties,
Particular instruction.
what happened after the last one?
My instructions that they have not gone together. They have not gone, but this is the view of the division bench that I also there that they should go together and try to settle their own dispute, material dispute, but my instructions then, they have, both of them are very rigid, my clients also. So I'll just talk with, I just call my, today just, tomorrow I have come, I just call my client today, what they have, otherwise you also can hear this matter.
You have called your client today.
Yes, in the chamber I have called today, appointment yesterday.
Respondent.
Lordship, I should take the instruction, Lordship. Kindly keep the matter next to Lordship.
You inform Mr.
Shatoki Basu.
Yes, and he should also speak to his client.
I just talked with him today, he told me that I was in Calcutta, he told no, there's no.
That there is chance of reconciliation.
Yes.
Then only things progress. Now you are saying is rigid. We don't know what.
No. I started my matter. Then the division men expressed the view, my lords. Then they went to the chamber. They sat together. I said then.
That you had said that there will be a reconciliation.
Yes. I have said.
On 6th November.
Yes,
ma'am. Submitted that you are hopeful to resolve the dispute between the parties.
Yes, ma'am. Well, you can take it tomorrow. I just take the instruction. Then.
There is a advocate for the respondent.
Lordship, we have some personal technicality. That's why he is not being able to attend the.
I'll get away. I mean, I just talk with him. I just talk with him on phone.
If necessary, Lordship, well.
You need not be here. There is no order requiring you to be here.
No, madam. But
No.
formally discharged also.
You submitted the report thereafter, one day again you were
Yes,
requisitioned.
that transpired from the first sitting, but thereafter, my lord, during course of the hearing, my lord, it was expressed, my lord, by the honorable bench that mediation has failed.
As jointly prayed by the party. This one give the date of Monday. Then an advocate who was earlier requested to mediate, who need not, Dylan advocates earlier who were requested to mediate, need not be present.
Item number 15, Lordship, I bring the other side.
Yes, what happened?
I bring for not today, Lordship.
No, no order. Model.
Item number 21.
इसको हटाओ नीचे रखें से
Yes.
My lord. My lord, yesterday my lord had asked me a question.
Announcement from 4/12/13.
My lord.
Announcement from
4/12/13, my lord.
4/12/13. And the vacation is in 2016.
16, my lord. 5/7/2016. 15/7/2016. When they handed over the keys to the plaintiffs. That is Exhibit C, my lord. At page 284. My lords had asked me a question yesterday with respect to the EMIs.
3.5 years.
Yes, ma'am.
6 months or so. So this for Schedule A.
Schedule A. My lord, Schedule B, I took instructions. The lease was valid till 2020. On the day when the main premises of Schedule A were vacated, the Schedule B premises were also vacated after 1.5 years, but that was within the period of lease. So, my lord, we have no claim in respect to Schedule B. With respect to Mesne profit,
Trying to ascertain what is the subsisting claim.
my lord.
So the subsisting claim is enhanced rent from 4/12/13
My lord.
till July 16 when it was vacated.
My lord, enhancement was from 2008 to 2013.
4/12/2008.
Yes, my lord.
4/12/2008.
To 2013.
13
Thereafter,
is the
agreement expired.
13 is the agreement, but with effect from 2008.
My lord, agreement was from 2005 with effect from 2003.
28 to 2005.
Yes, my lord.
So valid till 15.
My lord, it is
No,
2013.
Valid till
13.
Because it was
With retrospective effect. And my lord, after 2013, since they did not vacate, it was for Mesne profit.
According to you, Exhibit C is dated
15/7/2016.
Yes, 8 months approximately. Now, the areas difference
Yes, my lord.
on the entire period, entire, what do you want? What has been, what according to you has been?
My lord, we had before the previous circuit, my lord, the honorable court had the same query. What is our claim as on date? And court asked us to prepare a calculation sheet, my lord. Pursuant to that, my lord, we have prepared. My lord, today our claim is at 44,51,606.
This 2013 agreement incorporated a rent enhancement clause.
My lord, 2005 agreement at clause 4, subclause 3, my lord. 13 it expired, my lord.
Yeah.
And my lord, in written statement, they have admitted.
Yes.
And my lord had asked me with regard to the house loan and deduction, where was it? Was there any written documents? My lord, on that also, my lord, I had taken instructions. My lord, though that document, my lord, it was bit illegible. My lord, what I've done, I've made a typed copy of it. And my lord, in certified copy, it's still legible. My lord, may I hand over the certified copy and one Xerox copy?
Where is it? Tell us.
My lord, it's Annexure 1, Exhibit 1 in Part 2. First page. Page 123. My lord, there is 6. My lord, 5 and 6 is relevant because 5, this is a letter addressed by the defendant respondent to the plaintiffs. They were agreeable to initially issue a loan of 5 lakhs. And my lord, in the repayment clause, it has been stated to be adjusted out of total monthly rent payable by bank, 100% for 5 years and then 50% for next 5 years. Subsequently, my lord, there were further loans that were taken, but in all the arrangements, we are paying the EMIs. So that was not that it will be adjusted directly. They would pay me the amount in my savings bank and then it will be deducted from that bank account. For that, my lord, the corroborating factor, we had exhibited our bank statements, which will corroborate to our statement that the money was first credited in the account of the landlords. Then it was subsequently transferred. The EMI amount was transferred from that account to the loan account. That I'll place, my lord, through documents. But initial arrangement was in this letter dated 1911-1986. My lord. Now, my lord, kindly takes the impugned order, my lord. We are aggrieved, my lord, with certain findings which are not tenable, my lord. Page number 109, issue number 4, where the court has decided, my lord. My lord, it has been stated in para 2 in issue 4, my lord, that defendants, after expiry of 5 years, rent was enhanced 15% with effect from this on the existing rent, and lease of ATM outlet was enhanced 15% on this. Initially, enhanced rate amount could not be paid due to non-cooperation by the plaintiffs for not providing legal heir certificate of late Prafulla Kumar Ghosh or succession certificate and or probate. My lord, this is one of the main ground which the learned court failed to consider, that the moment we got after the death of one of the plaintiffs, we have intimated the bank by written communication. These are the legal heirs of these persons, and those documents are exhibited by the learned court. Yet the learned court did not take those documents and has come to a finding that we did not come. But that is completely contrary to the record. My lord, exhibit 7 series. Series of letters had been written, my lord. That is at page number 199, 991 of the part 2, my lord. 191.
To give a legal heirship certificate or succession certificate.
Yes, my lord.
You provide any of these?
Yes, my lord, we have provided to them.
Where is that document?
191, my lord. Yes, my lord. It's 17/6/2009 letter, my lord.
When we ask you whether we provided a certificate, you draw our attention to a letter.
Communication.
We ask you a certificate, you are showing us a letter.
Well, it's been stated here that it is the probate process.
Not a certificate.
Not a certificate. Communicating.
Say that you have not given a certificate.
My lord.
We asked you whether you gave a legal heirship certificate or a succession certificate. You have not given.
My lord.
So we didn't ask you to show letters. We asked you a specific query. You said the finding is wrong. The finding is not whether you wrote a letter to them or not.
My lord, my
Finding is whether legal heirship certificate or succession certificate was given. You have not given that. In lieu of that, you have given letters.
I have informed them they have died, and these are the legal heirs.
Saying only when they came to know he has died, then they asked for the certificate.
We informed them that they had, because my lord, what has happened?
Obviously.
They continue to pay rent. Now, I asked
And you continue to receive rent. That is also
with objection.
we don't.
Because my lord, we have in letters we have said they are not giving enhanced rate.
Anyway,
They are paying rent.
that comes later. The point is that you informed them, or somehow they came to know that he is no longer there. The plaintiff number 1.
My lord.
He passed away.
My lord. Yes, my lord. First.
The plaintiff number 1 passed away. The rest of you are the sons and wife. There are 2 plaintiffs originally.
Yes, my lord.
Both the brothers. Then they held some lands more than 40 kathas. 5 kathas was transferred to the son and wife of one. 5 kathas to the son and wife of the other.
Yes.
The other 4 kathas and odd remained intact with these 2 persons.
Yes, my lord.
Now, so the tenancy is on these lands.
Yes, my lord.
Now, when the plaintiff 1 and the other brother, only one of the plaintiffs died.
At that time, suit was not instituted. They died before the filing of the suit.
Obviously.
Landlord passed away, we informed.
Yes.
These are the legal heirs. My lord, what they did, they kept on depositing rent in the account of the landlords, but in an old rate. My lord, now they are saying they were, my lord, here the question is whether they were liable to pay an enhanced rate or not.
Question is, who will they pay it to?
Well, they have been depositing the rent. They could have deposited in the same account.
Original recipient's account.
Yes, my lord.
They have asked you for a legal heirship certificate or a succession. What prevented you from giving?
My lord, we have informed that the proceedings, whenever we get the proceedings, we'll give it to you. That is pending. The probate proceeding was pending.
Probate proceeding was pending.
So we intimated the proceeding is pending, and this is through the communications, my lord. And my lord, what has happened? They kept depositing the rent. If they did not know whom to deposit, they could not have deposited that part also. If they were depositing the rent in old rate, what stopped them from depositing the rent in the enhanced rate to the same account?
They don't say that they are not knowing. They say we are depositing rent, we continue to deposit. If you want a change of that account, you give us the document.
My lord, here the subject was,
Therefore,
we were demanding enhanced rate. It's not about on whose account they are paying. We just demanded, please pay as per the agreement in the enhanced rate.
So according to you, that amount that they were paying is not the enhanced.
No, my lord. That is admitted by them in written statement and in deposition that they kept on paying in old rate.
Old rent, okay.
So, my lord, my question is, if they are able to pay to some person in old rate, so what if they paid the enhanced rate to the same person? But this is something afterthought they have come after the filing of the suit. There was never a dispute
Yes.
with respect to this point.
Yes.
Now, my lord, we continuously, now what is most important is, my lord, our notice. Now, second quote, what court failed to say, they had, when we gave them a notice to evict, they gave a reply that we will not be able to evict within this time. We will evict within this time. We replied to that letter and we stated, yes, but your lease will expire on this date. After that, you have to give the new lease rent as per the market rate after the expiry. You can continue, okay, I understand, but you have to, since it is expired, now you have to pay rent as per market rate. And we have given them in that communication what would be the rate. And my lord kindly takes that, my lord. My lord, first is our legal notice. That is at page 205. Notice under 106. This was dated 28/5/2013, 6 months prior to the expiry. We wanted to determine the release. So we intimated 6 months prior. Please vacate the premises at the end of the
Twenty-eight, 5/13.
28/5/13, my lord. And my lord, para 6, 7, and 8 is important. That is at page 209. At 6, it says, I submit that on and from 1/6/1/2014, the lease hereto before subsisting shall terminate, and all relationship of lessor and lessee between my client and you shall absolutely cease. That you are requested to deliver vacant possession of the leasehold premises to my clients on the date as stated above. In case you fail to quit, you will be considered as a trespasser and ejected in due course of law, and you will have to pay damages, mesne profit, and costs until you are evicted. Now, para 8. That in terms of deed of lease, the lease rent has not been increased 15% with effect from 6/12/2008. And hence, you are also requested to pay area rent to my clients immediately, failing which my client shall be liberty. I'm very sorry. Will be at liberty to take steps as per law. My lord, so we have intimated in this notice also that you are paying in old rate. Kindly pay enhanced rate. Now thereafter, my lord, what reply we get is at page number 221. Letter dated 1/7/2014, my lord. my lord.
Yes.
Then thereafter, in the aforesaid circumstances, my clients are awaiting vacating of the said premises by you by 30/9/2014 and deliver
When the bank vacated the premises.
my lord
Before
2016.
Before they entered appearance in the suit.
My lord, I'll just check with the order sheet. They appeared in the suit, my lord. Suit was
Well,
filed.
that is vital, no?
Order sheet. Order sheet. It's me, part one.
Plaintiff was amended.
My lord.
Whether the plaintiff was amended, that they vacated the premises before their entrance, before filing of the suit.
They didn't vacate before filing of the suit, my lord. After filing.
It is of 2016.
16. They vacated after 3 months of the suit, my lord. 11/5/16. My lord, before they entered appearance, thereafter vacated, my lord.
Huh?
My lord, in page 83, my lord, 11/5/2016, they entered appearance in the suit. And the vacation was in July, 15/7/2016.
And suit was instituted on 3/6.
9/3/2016. Suit was instituted, they appeared before the learned court, and after 2 months, they vacated.
Yes.
My lord. So, my lord, these two findings that court has held that we have given them a permission to stay is wrongly interpreted, my lord, from the documents. They could not vacate, and we have intimated that if you are unable to vacate, you need to pay at this rate. So, my lord, this cannot be construed as we are allowed them, or we have waived the notice under section 106. And that is what the court has found, my lord, and we are aggrieved by that finding. Because we have never waived that right. We have told them, if you are not vacating, then this is the rate you have to pay now, till you vacate. Then, my lord, there is another finding in the same issue, that default. My lord, we never claimed that they have defaulted. Our always claim was that the rent payment during the enhanced rate, they have not paid. They have paid rent in the old rate, and that was recorded mistakenly, my lord, that they are not defaulters. My lord, page number 110. It appears the defendant never defaulted. But my lord, my prayer is that they have paid, but in old rate. And that is what evidence has said. The bank has admittedly in the written statement.
Issue number 5.
Issue number 4 only, my lord, at the end. Whether the defendant was required to mesne profits or compensate different questions, so far the payment of rent is concerned, it appears the defendant never defaulted. We never said they have defaulted, but our claim is they have always paid in the old rate. Agreement has, the contract suggested the enhancement, so it ought to be paid in enhanced rate. That they have not. And subsequently, my lord, they have overstayed. That issue number 5, my lord. Issue number 5 is with respect to waiver of 106 notice, whether it has been waived. But my lord, from the communications, nowhere it can be construed or interpreted that the plaintiffs have waived their rights. Because, my lord, the documents that has been referred by the learned court has been read in part and not as whole. The entire document, the entire letter has to be read together. We appreciated that they were facing difficulties, but we also intimated that this is overstaying since it is expired. And the learned court below failed to interpret the documents to its letter and spirit.
There's no objection is wrong. According to you, the finding that there was no objection is wrong.
Yes, my lord. We have objected to in every communication, my lord. Every communication before filing of the suit, before expiry of lease, we have asked for enhanced rate. Then after expiry, in our notice determining the lease, we have asked for enhanced rate.
This is not with regard to enhancement. This is with regard to your continuance.
My continuance, my lord. Now, continuance is subsequently, my lord, my letter dated. My lord would see my letter dated earlier, 227. I have clearly stated, if you are staying, you have to give me rent as per the prevailing market rate.
With reference to that letter, paragraph 5 of that letter,
Yes, my lord.
you are saying that this finding is regard issue 5, that there was no objection was raised, is not sustainable.
Is not sustainable, my lord, because we raised it. And bank themselves have admitted they have not paid the old rent and they have overstayed. From the documents, since the lease expired and the date of vacating, my lord, the period is construed to be trespassers since we have stated to them in our letter. But thereafter, my lord, at page number 239, the bank again addressed another letter to the plaintiffs, my lord, wherein they again said that they could not vacate in 2014, September.
Stated in the plan that he becomes trespasser.
Yes,
after in which paragraph?
My lord, in paragraph 14, my lord, we have given that pleadings. Page number 7 of my and in that notice, we have stated, my lord, that if you continue, you will be considered as a trespasser, which I had referred to earlier, my lord. That is at page number
229.
220, my lord. I wish to remind you that you have failed to quit and vacate the premises and you still occupation in premises. Otherwise, you'll be considered as a trespasser.
In which paragraph you have stated?
My 209, my lord. I'm sorry. Para 7, 209. In case you are failure to quit the leasehold premises as described,
Your
you will be
letter, have you
considered.
stated in the plan?
My lord, we have, this is what we have stated.
It was stated in the plan, in which paragraph?
Okay.
The initial entry is based on a lease, they will become a trespasser.
My lord, but after the lease expires, and if it is determined before expiry,
They become trespasser.
my lord, if they did not vacate, my lord, it was upon them. We have given them an advance.
See you whether they are required to vacate or not. They are asking you an entry in accordance with law, and if the lease has lapsed or they have failed to vacate, their status will become that of a trespasser. What is the law?
My lord, it is not a holding over tenancy, my lord, but because we have not permitted them.
That is not the only option.
My lord,
It's not that either
overstay.
they will be a holding over or they will become a trespasser. There is another concept also. Will they be considered a trespasser in law? We are asking you.
My lord, it ought to be, because my lord, since the
We don't know. We are not asking for submission.
Yes, my lord.
You show any law that once they have entered on the basis of a lease, if they overstay, they become trespasser. Can you show any judgment on this? You have used the word trespasser, therefore we are asking. You say no holding over. That is your case, that it is not a holding. Obviously, they will say it is a holding over. Under section 116.
Yes, my lord.
Of the TPA. There is another concept, holding over, and there is another concept, tenant at sufferance.
Tenants and sufferance.
Now there is a third concept of trespassing. You have
the
expression trespass.
My lord. But it is,
Therefore, we are asking.
it would be sufferance, but my lord,
You repeatedly use the word trespass, and then we ask.
I have to go with what is pleaded, my lord. I cannot plead something from the bar.
You are here to assist us.
Yes, my lord.
Therefore,
My lord, it's not a holding over tenancy, but it is by sufferance. My
you
lord.
don't know what it is. You may say, but how you elevate it to such a position of a trespasser or bring it down to such a level as a
My
trespasser?
lord, even today, my lord, the issue would not be that
Trespasser would always be someone who enters
unlawful.
Once the entry is lawful, they can become a trespasser.
I'd submit to that. But
Before we ask you, you can show some law, then you
that,
can always enlighten us. We are here for them.
but today, my lord, even though we have claimed in our letters, if they are staying over, but they have to give that amount, what we have claimed, because landlord is the only person who can decide what he expects from his property. And there is nothing to suggest that we have demanded anything that is not prevailing market rate. Because my lord, they...
In the response, once you have written to them,
Yes, my lord.
that 229, Communication Act 229, paragraph 5.
Yes, 209, my lord. 229, yes.
209 is your legal notice.
Yes, my lord. 229 is after vacate.
Yes. So
After expiry.
after expiry, 229, did they respond to para 5 by any communication?
My lord, they again wrote a letter dated 15/5/2015. They did not deal with any statements that we have made. My lord, that is at 239. They just said that we will vacate on this date. 15/5/2015, my lord. Without dealing to our letters, my lord, without responding to...
Not in response to that.
They did not respond to our letter, my lord, but they only sent whenever they felt necessary. They addressed us letter that we will vacate on...
No dispute that they received that letter.
No dispute, my lord. My lord, then to response to this also we have given them letters, my lord. Page number 244.
Asking you whether 17/7/14 communication was responded by them.
Not in letter and spirit, my lord.
Any response?
No response. My lord, only when we asked when we wrote to them, they just gave us letters in reply, which I had earlier shown, my lord. That is at page number 229. These kind of letters they have answered, but they never answered any queries or any, we asked for enhanced rate. They never replied to that. They kept quiet. We asked for vacating and giving it a market rate. They did not reply to that point, my lord. But they kept staying in the premises. The only response came in the written statement, where they have admitted that there is an enhancement rate. And in deposition, the managers have deposed that we continued to pay in the old rate. My lord, kindly take page 19 of my, this is a written statement, my lord, where they have admitted there is an enhancement rate. And the rent shall be enhanced 15% after expiry of 5 years beside other terms and conditions. But para 14, admission that they paid in old rent. That is at page 23, my lord. If my lords could take page 68, this is the cross-examination of the defendant.
Yes.
My lord, in page number 68, 69, my lord, the depositions, my lord, page 69 particularly, it is clearly admitted. It is a fact that as per the lease deed being number this, it was an express stipulation that monthly rent could be increased at 15% after expiry of 5 years from 6/12/2013, and new rent would be this per month.
Don't go to that, they have never denied or disputed this, even in their response.
Yes, madam.
They have not said so. They admit to it. That there was an enhancement clause and it was to enhance in 5 years. And that they are saying we are still ready to pay. They don't even deny the liability.
But they have not paid, my lord.
That's not required to be established. So the issue is whether a non-payment of that admitted amount is sustainable.
Non-payment, my lord, it is our valid claim, my lord. It is a lawful claim that has come from the contract.
That's not a fact in dispute.
Not
Therefore,
in-
we are not asking you to
Yes,
go into the evidence in this regard. In the pleading itself, they have admitted hold of the liability, they're expressing their willingness to pay. Now, whether the non-payment was justified or not,
But that is not justified because if they were paying in the old rate
decide,
to an X account.
that we'll decide.
Yes, my lord. This is my case that.
Your case that they should have, because if they can pay an X amount, why not Y amount?
Yes, my lord.
This is your.
Yes, my lord. Because there was nothing new. They are continuing to pay. Now, if 10 rupees has increased, if they pay the 10 rupees, it will go to the same account where they are paying the rent in old rate.
One
So-
factual dispute one factual difference or development, a subsequent event which may be relevant, we have not addressed on that, is the renewal by the original plaintiff. The renewal of the lease and the original grant of fee. Original grant was in 87.
87.
The renewal was in 2000.
With effect from 2003 on 2005.
But with effect from
2003.
So in 2005, plaintiff number 1 was still alive.
Yes, madam. He died in 2008 or 2009, madam.
So in the earlier lease of 87, were the sons dead because by then had the transfer been effected?
No, my lord, it happened in the year 1997. My lord, there is a deed of agreement.
So
Subsequent.
therefore, this enhancement clause came into existence after the transfer, prior to
Enhancement clause came in the new lease agreement, my lord.
after the transfer.
After the transfer.
What is the date of transfer? It is stated in the plaintiff.
My, it is, there is an agreement to that.
That's stated in the plaintiff.
Yes, my lord. 27th day of January 1987.
Both the transfers of 27/187.
Yes, ma'am.
They are of the same date.
Yes, ma'am.
And the deed, original deed is of which date?
1986. It is not a deed, my lord. It is a
Lease.
not a lease also, my lord. It is a letter through which it was inducted as a tenant, my lord. Bank has accepted our offer.
What is that?
My lord, that is at Exhibit 1, my lord. And may I give a typed copy?
You have not stated anything about that in the plaint.
My lord, I have stated. My lord, in the first paragraphs, my lord.
Effect from 5/12/88. There is a written agreement of 27/3/87.
27/1/1987.
7/3/8.
The lease dated 27/1/1987, my lord. Para 2.
That lease
Lease, yes, my lord. I am mistaken.
Sir, that
Para
is
5.
in favor of the other plaintiff.
Yes, my lord. Para 5 and 6. Written agreement dated 27/3/1987.
27/3.
1987.
Where is that document?
My lord, that is at 126.
No, this is not. This is the lease that you are talking about in paragraph 2.
That document has not been exhibited. But the lease, the subsequent lease has been exhibited.
Have they said anything about the initial?
No, my lord, there's no dispute with respect to that one.
We are not on dispute. We are in whether any situation as regard the landlord, who is the landlord? Any ambiguity has arisen in between the first agreement and the second agreement?
No, my lord.
If so, then there may be an occasion to say we don't know who to pay the enhancement. If not, then
There was no, my lord, because after that expiry and new agreement, there was no dispute at that period, my lord. Dispute cropped up after 5 years of the second lease, when they failed to pay the enhanced rate, my lord. Till the first 5 years of the second 2008. After that, since they continued to pay in old rate, we demanded in enhanced rate. They said, give us the document. We said, we will give you once we have it. And we informed these are the legal heirs. You please give it in their account. They continued to deposit the old rate, but did not deposit the enhanced rate. Which my lord has rightly said that they are also admitting they have the liability.
there have been so many words they have said.
Said it, my lord. No dispute to that, my lord.
In the pleading, so therefore, if there is no dispute in the pleading, we need not go into the evidence. on
Evidence.
this.
It is an admitted fact. But that the impugned order, my lord, it has not been considered in that way.
So according to you, that allowing them to continue was not, cannot be termed as a extension of the
Tenancy.
tenancy.
It is sufferance. Because we have every time sought for, if you are staying, then this is the rate. If we had given no reply, then my lord, if we would have kept cup quiet and they could have continued, then it could be holding over, my lord. And we have always objected to receiving of the rent also, my lord, because they were keeping on depositing in old rate. We asked them in enhanced rate in every communication, but they did not respond to those letters. So it is deemed admission on their part. Now, after the suit has been filed and legal men have come into...
In between 2008 and the vacation of the premises, you took no steps.
My lord, we have written series of letters, my lord.
So you took no steps to ensure that they pay the enhanced rent.
My lord, we are writing letters to them, my lord.
That's what we are saying. You took no steps. You just kept writing letters after letters.
We demanded, we raised demands.
For 7 years.
7 years. A continuous series of letters are there, my lord.
Why you stopped at 7 years?
No, my lord, we continued till filing of the suit.
Why did you stop till filing? You could have continued writing letters.
No, my lord, now one suit is there, my lord. Why would we?
There. Yeah, why you decided after 7 years to take that right enforced to a court of?
My lord, because we want at our initial stage, my lord, they were in possession. Our suit, they have given us, my lord, being a banking.
Continue to shoot off letters for another 10 years.
That is not the case, my lord, because now it's a bank, my lord. It is not just any individual or person who, my lord, a bank. Even we understood, like they are having a safe deposit there, lockers there are customers. Those are things, my lord. It is not a fact that.
We are on the enhancement. According to you, a right to the enhancement accrued in 2008 itself.
Yes, my lord.
So why you took no steps till 2015? You could have continued to write. Why in 2015 you took steps, or 16? You could have continued to
My
write
lord,
letters.
first, my lord, when we gave them determination notice under 106, my lord, we stated to pay the enhanced rate. They told we will vacate on this date. Now, my lord, they gave a word, they will vacate. So, my lord, the plaintiffs did not want to go into controversies also, my lord. If they were vacating it and they demanded, give me the rent also. They did not answer to that. My lord, there is, my lord,
You are asserting a right. How you say it is a controversy?
my lord, they are not giving a reply to that.
You are saying that
Yes.
you got a right to the enhancement from 2008.
Yes, my lord.
We are asking you why you were not diligent enough to immediately take steps. Forget about termination. If it had not terminated, if it had again been renewed, then would you have been happy with the unrevised rent?
Man, that is why we did not renew it. The reason we had to determine the tenancy was because they did not pay in the enhanced rate. And my lord, we did not terminate it before the expiry. On expiry, we told, please give in this rent and then vacate also. They did not vacate, we instituted a suit.
So rather than proceeding for the enhancement, you wanted them to vacate.
Yes, my lord. Enhancement, we had a demand. We raised that demand while asking them to vacate.
Therefore, there are two completely different things.
Yes, my lord.
Cannot be merged into one. There is a right which accrued in 2008.
Yes, my lord.
In spite of, other than writing letters, you did nothing till 2006.
But they were in, this is a continuing cause of action, my lord. They continued to.
It could have continued for another 5-6 years.
But my lord, we have.
Say continuing cause of action.
Yes.
Then, you see, we are trying to judge your conduct. What is in the, what was you looking for? What is the right here that you are trying to agitate in the proceeding? For 7 years, you have taken no step for that enhancement. They have been telling you that you give the details, and you have been saying no, you pay them.
My lord, we have given them the details and we have said that.
You have never given the certificates. You have only been writing letters.
Well, what was in our possession, what was not in our possession, I could not have given, my lord.
And where is the fact regarding pendency of the probate proceedings brought to them?
In the notice. Yes.
Thanks, sir. Back up.
First one, letter consummation.
Page 191.
191.
Have you made any statement
234, my lord.
in this regard?
My lord, page 234. my lord.
In your claims, have you stated anywhere?
Letter dated 26/3/2015. Page 230.
233.
Para 2, my lord, at 234.
Is it your case in your claim? The evidence will only corroborate the facts.
The letter. 2015.
You are not even given any detail of the probate case.
Correct.
You have not stated even what is the probate case number, nothing. You are only saying probate has not been given yet. In which case? Where is the pendency? Where is the fact of pendency for probate case? The probate of the said will has not yet been granted by the learned court. Which court, in which proceeding? And where have you made this averment or statement in your pleading?
Yeah, condition stopped.
But we have referred to the letters in our pleadings,
So you have not stated anywhere in your pleading that in the probate.
not in the pleadings.
Yes.
State Bank.
You said that the notice to quit has been passed. What was said? They said the no step was taken to be part of the plenty. To hit them.
State Bank.
Anything else?
My lord, I just wanted to place with respect to Mesne profit, my lord, a decision of
Judgment.
judgment.
Can one be saddled with a responsibility for making profit in a holding over?
My lord,
Can such a claim be made with respect to a period of holding over?
substance. My lord, I need,
Relying upon a single judge bench before a division bench, that also of another high court.
my lord, I am not referring to this, my lord, because there is a reference of a honorable Supreme Court judgment.
So you come with that, why?
My lord, actually, I just had. The reference is there of the honorable Supreme Court in this judgment, my
You
lord.
are relying on the Supreme Court.
My lord, it
judgment.
is referred by the honorable bench.
You will place that judgment.
That I am not equipped with, my lord, presently, but the principle, my lord, what is elucidated is, my lord, it is in the case of Hardesh Oreos Private Limited versus Head Company, 2007 5 SCC 614, wherein the Honorable Supreme Court, Swarup Singh Gupta Toto, held that after the expiry of lease, the landlord is entitled to receive charges which are paid by the tenant for use of and occupation, inasmuch as a tenant cannot stay in a tenanted premises without paying use and occupation charges. A lease in an issue of a bilateral action or contract between the parties, and mere payment, unilateral action of depositing of rent cannot mean that the fresh tenancy contract can be said to have come into existence, much less the period of 5 years for which the law there had to be registered instruments. Now, my lord, after the expiry, there was no fresh lease agreement executed.
Who is saying there was a lease?
Yes, my lord. So, my lord,
It's nobody's case that an agreement was.
my lord,
The court has held That you permitted them to continue.
Yes, by my letters.
Permitted them to continue, can you claim means profit, we are asking?
But my lord, my case is that we have not permitted them to continue.
Then why you are relying on this? That's what we are saying.
This is saying that if they have continued to stay and the lease has expired, the mesne profit has to be granted, my lord, along with interest. That's only the proposition which I wanted. My lord, this 2006 is there, my lord. Yes. बोला तो था अभी. And this also deals with the waiver of notice, my lord. Para 7, 6, 7, 8. The mere acceptance of rent after expiry of period of lease did not signify assent to the continuance of the lease. My lord, the learned trial court has held that since we continued to receive rent, it was continuing tenancy. But okay.
It's not a different issue. It's whether there is.
My lord,
Rent
the
is
Honorable,
accepted.
the learned trial court, my lord, in our case
But
has,
this has nothing to do with means profit.
no, my lord, they, in our impugned order, my lord, the court has held that we have accepted the rent, which is a unilateral act because it deposited from their account to my account.
So the court has not said that a tenancy has come into existence.
My lord, this is what the court has said. We have waived our right.
Your case, the court has not said that tenancy has come into existence.
But the court has said we have waived our notice
Right
under,
for what? Read.
for mesne profit.
Therefore, this is this judgment that you are relying upon. It is whether by such act a new tenancy has come into existence or extension. No, that's not the
No,
case.
yes,
You still
that
have
I
right-
wanted to place. There is no waiver of notice under 106. my lord. And my lord, mesne profit comes from section 2, subsection 12 of the CPC.
Why you are referring to this judgment?
My lord, waiver of notice, my lord, because court has held that we have waived our rights.
Waiver of notice, you have, in this case, the court was not required to pass an eviction order because themselves they have.
They have vacated, but after the filing, my
And they
lord.
have never resisted that they are not liable to vacate. Here, the tenants were resisting that they were not liable to vacate.
My lord.
Because for 2 months the rent was received. They say we continue to be a tenant.
Yes, my lord. And my lord, with respect
It's
to
not the issue arising.
mesne profit, my lord, it is derived from section 2, subsection 12, my lord.
We are asking you whether you have any judgment to support what you are saying. This has nothing to do with it.
But my I would refer to section 2 of CPC, my lord, subsection 12.
Anybody want to do?
MC. A profit, my lord, the definition from CPC, my lord, mesne profits of property means those profits which the person in wrongful possession of such property actually received or might have ordinarily diligence have received therefrom, together with interest on such profits, but shall not include profit due to improvements made by the person in wrongful possession. Now, my lord, this right has come from the court that once the possession wrongful after the expiry, my lord. Now, after the expiry of the lease until the date of vacating, I have made a demand, my lord. That would be my mesne profit.
What you would have ordinarily received.
What I would have ordinarily received.
What you would have ordinarily received.
My lord, for that, my lord, I have given them that my market prevailing rate is rupees 70 per square feet. Now, my lord, to that effect, my lord, what I have done, my lord, I had filed an application before the learned trial court to adduce further evidence to show that what is the prevailing market rate by way of incorporating a deed of lease which the defendants had executed with some other person in the close proximity of the present landlord's location. The learned trial court did not allow our document to come as an exhibited document. My lord, to subsequently, my lord, I had filed an application before this honorable court to adduce further evidence, that is can 2. Now, my lord, while considering that application, my lord, the honorable coordinate bench had directed that can 2 shall be taken up when the final hearing of this matter will take place. In that, my lord, I have showed the document wherein they themselves, with a similar area, they agreed to pay a rent of 1,31,000. That is almost what I had demanded, 70 rupees per square feet. But that is still pending before this honorable court, my lord. Now, my can 2 is also on record, my lord. So, with respect to that, my lord, it is not. My lord, it must.
It's not in the paper book.
Not in the paper book, my lord, because I was not allowed. My lord, the application was, the order says I.
An application for additional evidence, can it be allowed like this? It has to be considered with the appeal at the time of hearing.
Yes, my lord. That is what the honorable court has
This
directed.
is the law.
Yes, my lord.
Therefore. Very recent judgment also on this. Very recent. And
2, my lord.
As to under what circumstances an additional evidence can be. Now that we have been.
My lord, we had filed this application for adducing evidence before the learned trial court, my lord, before the judgment was passed. But my lord, the learned trial court just took a judicial notice of that document and said it is a registered document. It need not be exhibited. I have taken a judicial notice.
So this is part of the exhibit.
No, my lord, it could not, my lord, it could not be exhibited because trial court just took judicial notice but did not allow the plaintiff to adduce evidence.
Not additional evidence.
Well, that is why,
Considered, then it is not additional evidence.
my lord,
If it is already considered by the trial court, can it be called as an additional evidence?
my lord, my application was not allowed. And my lord, that is also one of the grounds in my appeal that these ought to have been allowed. And
Application, where is that application that he made before the trial? And where is the order rejecting that?
my lord, page number 100, my lord, order dated 28/2022.
Page 100.
Yes, my lord. Order number 43.
Have you challenged this order? Have you challenged this order?
In the first appeal. My lord, because after a few days, my lord, judgment was passed. 25, my lord, this order is 28/2022, final order.
Petition was rejected. You
My
had to
lord.
challenge, you had to challenge.
My lord, the judgment passed immediately thereafter, my lord. 25/8, my lord, we have come before the honorable court by a first appeal, along with an application for adducing further evidence.
After this order, when the final suit was finally decreed,
My lord, 25/8/2022.
just 4 days after.
And immediately thereafter, my lord, the appeal has been filed.
No, 2 dates are fixed for argument thereafter. Thereafter, judgment was passed on 25th August.
Order passed from 19 September.
No, order dismissed 25/8/22.
What is it? What is it?
I pay 102, man.
102.
25/8/22. Today is fixed for judgment. Parties
there
are
is
present. Judgment is.
After
His lordship is saying that thereafter on 2 dates it was taken up for hearing.
My lord, next 24/8/22, my lord, for arguments, my lord, then for judgment.
after rejection of your petition, there are 2 dates
My
are
lord,
fixed.
my lord, kindly seize the date. 28/22, my order rejection. Then 24/8/22, final arguments.
And 25th judgment.
25th judgment. And this is the first appeal, my lord. I can challenge, my lord, in first appeal, I can challenge, make place challenge in the any orders passed during the.
Yes, you can.
And that is, my lord, because the first appeal has, appellate court has the.
We are not in the least trying to suggest you can't do that.
But my lord, even though, my lord, I can also file it at the stage of appeal.
Your petition was for recall of witness.
Yes, my lord. So that I could exhibit one document that was very necessary, that was with respect to my masonry profit, how I am calculating it.
You could, so that you could.
The market rate that was prevailing in that area,
How that document is not an exhibit.
Not an exhibit.
That there is no pleading about this in the claim.
My lord, this
So
was subsequent.
how you can be
This
permitted
was
to recall a
subsequent
witness?
documents, my lord. Yes. I understand.
Unless you introduce an amendment to the plaint, unless you introduce this exhibit in the record, how you can be permitted?
That I understand, my lord. These are.
I'm not saying you can't challenge, you can challenge everything, we know. All orders passed in the suit can be subject to claim. And you see, you're looking at the order, therefore we have looked at the provision also. Every time we go through the things, we look at the provision.
My lord, my question difficulty was when the plaintiff adduced evidence, this document was not in possession of the plaintiffs.
So,
After-
therefore you say, you recall the witness and let me show this document to him. Can you do this?
It ought to have been done by amending the plaint first, my lord, but
Pleading, unless they have had an opportunity to give their reply to that by filing a written statement, deal with these issues, how it can be introduced, just like that for the ask.
my lord.
Even if you can challenge, what do you expect?
But even if, my lord,
This could not have been taken into.
taken into record, my lord, that court has done it, my lord. The court took a judicial notice and the plaintiffs thought this is sufficient to
Not the
place it.
judicial notice. Court has specifically held that there is no pleading to this effect.
Yes, my lord, that I do not deny. But my lord, this document is with respect to just, my lord, for this we do not even need, my lord, what the law is laid. We do not need to produce any evidence in this regard. It has to be ascertained, my lord. I have given them an amount now. My letter, my lord.
The valuation of land is being done based on introducing such material in the suit. You are saying does not have to.
My lord, I have given them a rate because I am the landlord. It is
that you have said.
Exactly, my lord.
We are on this document.
My lord. But
You
my
already said 70 rupees.
70 rupees per square feet. That demand was clear, my lord.
Yes,
And if they did not agree to that, they could have vacated before the expiry of lease.
that you have said. We are on this. How you can introduce this document at this? And if that was, and how you have filed it as a application under 41 Rule 27, then you have already tried to do it in the court below. It's not an additional evidence. It is not that you, despite due diligence, you could not produce it or something like that. How you have filed an application under Order 41 Rule 26? You have already dealt with this document in the suit.
Yes, my lord. I had filed it, my lord. It
How
was,
it can be an application under Order 41 Rule 27? What is the provision?
my lord, for adducing additional evidence that was.
And what is the law?
My lord, first, the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted. And this is one of the conditions, my lord. It ought to have been admitted, but it was not. The party seeking to produce, my lord, this is it. Additional evidence establishes that notwithstanding the exercise due diligence, such evidence was not within his knowledge or could not after this.
How can you meet this requirement?
My lord, but the first one.
This was well within your knowledge.
But my lord,
You
first
took
document, my lord.
due diligence, you produced it in the court. So relying on one sentence of that section, you should be allowed.
My lord, it's or, my lord.
That has to be read as together.
My lord, it's either the court whose decree appeal is preferred has refused to admit the evidence.
Yes.
I am with this clause, my lord. It has refused.
And you have come with the recent judgment on
My
Order
lord.
41 Rule 27.
My lord.
Delivered perhaps last month. Dealing with the entire circumstance.
My lord, my issues are limited to that extent, to that document, my lord. My lord, that is why, because there are
You have filed an
application.
under 41
Rule 27.
How do you propose to sustain that? We are asking you.
My lord, first part, my lord, we have produced this document and
Where
request.
is the judgment? Where is that judgment? The recent judgment. Come with any judgments neither regarding means profit nor regarding.
Well, means
41
profit.
Rule 27.
The paragraph. MCO. My lord, may I rely on a division bench of Delhi High Court? एक copy उनको भी दे दो. Now 2011 SCC Online Delhi 3715. Para 3. On the aspect of the date till which Mesne profits are payable, there is no doubt that Mesne profits will be payable till the keys were deposited by the tenants in the court on, my lord, and it was till the keys were deposited. Inasmuch there are admissions noted in the impugnment that the tenants had removed the walls, and original project tenant was restored only on this. Now, my lord, in our case, my lord, there is an exhibit C which says when the keys were handed over. The entitlement of a landlord to claim Mesne profit from a tenant who is in illegal possession the above provision has been interpreted by various judgments that ordinarily the Mesne profit which a landlord is entitled is against a tenant who continues to stay in the tenanted premises after the termination of the tenancy is the amount which the premises can fetch if let out on rent during the period of illegal occupation by the tenant. Para
Is it
3,
a
then
division bench judgment? or
My
single
lord?
bench? Is it division bench judgment or single bench?
Division. My lord, Justice Valmiki and Justice Mehta.
Perhaps not. We don't know whether it is a.
By the top of the page.
Yes, we don't know whether it is a printing error because his lordship was Justice Valmiki Mehta.
But my lord, what I see, my lord, because
And if you go through the judgment, it says in my opinion only. It does not say in our opinion.
but
And it
my lord,
starts with an oral order of Valmiki J. Mehta, and at the bottom there is no such thing as I agree. Go to the last of the order.
my lord, because my lord could see.
We understand why you have done it. His lordship's name was Valmiki Mehta. Perhaps that J, perhaps it is printed in.
Misprinted twice.
Because you see the opinion of the court everywhere, it says my opinion. It does not say our opinion anywhere. And there is no I agree at the bottom. At the end of the judgment, there would have been one line.
Yes, my lord, Alien. Otherwise, there could have been this order has been passed by one. My lord, I could come back with a Supreme Court on this, my lord, because these are settled principles of law, my lord. That is why I did not want to trouble my lords.
No. We are here for this. What do you mean to? So you cite the judgment tomorrow, and after that we will hear them tomorrow itself.
It's not a day after tomorrow. Take feedback from the bank regarding the claims as given.
What copy?
They claimed the money, what do you amount?
What an instruction now you have to take. Everything is confined to the record. There's nothing new we are allowing.
That was just the, my lord said, the coordinate bench had directed to what is our.
Notification is not part of the record.
No, my lord.
He's saying that this is my assessment.
Assessment. My lord had asked us to prepare so that my lord wanted to know what is the quantum of.
Look into this or not. We don't know. Why should we go in for a quantification? Normally the court will hold what is his entitlement, and that will have to be quantified if we vote. If not, then.
Yes, madam. Actually, it was just directed to quantify for the my lord's convenience to understand where the dispute is.
Some bench has asked you to give, you have
Yes,
given.
ma'am.
No, that is not anything. Yes, please take up. Submissions have been concluded on behalf of appellant. Yes, with the paper. You did not send nothing. You not read any. Item number 23.
আপনার করা আছে
Part of the
I am for that. Well,
easier from the past.
other cities, not.
All the next. See what this looks like. Let us see.
I am waiting, my lord.
24, 25, 26, 27.
Praying for not today.
Yeah. 28.
Number 26, I was. Respondent, my lord. All the name.
29.
29, my lord, I am not the respondent. I got only late by Mr. Vikram.
And who's for the appellant? All the name.
30.
My lord, 30 I am for the appellant.
Both sides are here, huh? Not to this, but both sides are here.
My lord, the respondent, my lord, I've served, my lord, this matter is pending since long, my lord.
All the necessary. 31. Here tomorrow.
My lord, I am for the respondent.
In
31. Appellant is not here.
Appellant
Appellant is not here, call the next. 32.
I am for the appellant.
Unless
Other
both
side
sides.
also they are just sometimes before. Lordship, can it be taken up on next Thursday? It would be
You
better
are the appellant.
yes, for my preparation.
Any interim order is there?
Interim order for not to marry, nothing more.
Let it be here tomorrow. We'll, in his presence, you make a prayer for adjournment. Yes.
Lordship.
33. 34. 35. 36.
May I please your lordship?
Both sides. Side are here, side are here.
No, there is a direction required, lordship, in this matter. 36. Ma'am. Lordship, this is a appeal against acquittal. A 390 direction has already been passed. But whether it has been complied or not, that I don't know. The client is not in my touch. The order is at page 163. 390 says that the acquitted person.
You don't know whether he has been taken in custody or not.
No, not in custody. They are supposed to appear in the. They should appear before the trial court and took bail, and also to appear here.
So how it is to be ascertained?
Lordship, the person direction on the state so that they will take a confirmation or take a report.
We asked you whether both sides are present.
Lordship may pass that direction only. Whoever in the state, he
Seem to be here, otherwise tomorrow he may say I will not.
Nigoy take rakna. বাইরে বসে রয়েছে. Lordship, can I take a passover kindly?
You remain as it is tomorrow.
Tomorrow, that will be good. That will be good. Because if this will, unless until this order will pass, I cannot start my hearing.
37, you may tell him that tomorrow he.
Lordship, I'll do.
37. 38. 39. 40. 41.
My lord, in item number 41, I am appearing on behalf of the appellant. My lord, I am being led by Mr. Shekhar Bosch. My lord, I am praying for next circuit as because
Lordship, I have to say
Boshu will
something in
come.
this matter. I have been appointed by the Calcutta High Court Legal Service Committee. I am, with due respect to my senior, I would like to add something in this matter. If your lordship may kindly take up the matter tomorrow and
All right,
final argument.
tomorrow we'll see.
I'm grateful to your lordship.
Grateful.
42. 16.
হয়ে গেছে কালকে
44. 45 and 46. 47. 48. 49. 50. 51. 52. 53.
Don't understand.
এই বলে দিও 73 টা নেক্সট অ্যাপ্লিকেশন
Judge, naam se stand.